Well, good evening, 9:07 p.m. East Coast. Happy Friday. It is Friday, October 10th, 2025. Cheers to all of you who made it through the week. It was quite a week. So, welcome to Friday, everybody. Whoever had their wagers on 9:07, you have won absolutely nothing. I don't know what I can give you, but welcome to the Friday evening. Hope your week was great. Ian, how are you, buddy?
It's been a week.
Do tell.
It's like this could be over by now.
Yeah. I mean, it's been kind of wild. I had a trial on Tuesday that was supposed to be shortened. It did not end up being a short trial. It was a full day trial.
It never is.
It never is. And the courthouse, I think, when was the Alexandria County? It came up. Alexandria City Courthouse built. When was it built? I think it was built in 1870 or 1871. So they can't manage their temperature. And
of course, that is the constant problem with old courthouses.
It was so hot. I wanted to die. And it was a full day hearing. It wasn't supposed to be a full day hearing. So just sweating bullets. And of course, giving closing arguments in the hearing when you're hot and angry is always a recipe for phenomenal closing arguments.
I mean, I'm in favor.
Well, it ended up working out great. Honestly, maybe hot courtrooms are the solution, not the problem. I don't know, but you remember the Fairfax County Courthouse when you were here for the deputy heard, right?
Yeah.
They keep that courthouse nice and cooled off, except for one wing of it that's like in direct sunlight. But it's pretty stark contrast to what was happening on Tuesday for me, just generally speaking. How's your week? Apart from that,
just long. That's all.
That happens. It happens. So Let's see. Chat, how are you guys doing? Looks like Boppet coming in. I can't believe it's been 37 months you've been a member. 37 months. It's been more than 3 years. I can't believe I've actually been streaming for 3 years.
Yeah, isn't that weird?
Yes and no at the same time. I think the concept of time has now become just an ever increasing issue because now there's not enough hours in the day. It used to be there weren't enough months in the year. Then there weren't enough days in the month, and now they're not just hours in the day. I end up finding myself chasing my tail half the day and never end up getting half of what I need to get done. Miklos is saying I was late. Everyone's calling me out for being late. I was late. I admit I was late. I also was listening in intently on a dispute, a rather loud dispute between Mischief Manager and Leo. They had a disagreement. Leo said it was time to be loud and bark, and Mischief Manager said it was not time to be loud and bark because the children are asleep. And
I see.
They decided they were going to have that discussion in screaming match form. So, yeah. Now, Leo, whose new nickname is Stompa, because you just hear him stomping around the entire house all the time, is protesting because I think Mischief Manager went upstairs and left him. So we're just going to listen to his footprints, just tonka, 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 tonka. But that is just, we're going to call it par for the course. That's what we're going to call it. So we've got a couple of stories this evening. It seems like there was stuff going on this week. But then again, I don't know. I think people are saying the audio is weird, so I'm just double checking to make sure that all of my audio settings are correct. I think we're good. Let me see. I think we're good. We're going to call that good. That's what we're going to call that. So, a couple of weird stories this week. Not a whole lot We had Mark Sanchez getting in massive amounts of trouble. That was oddly enough last week, but we have a civil complaint now to talk about.
That was
Mark Sanchez. Go ahead.
That's like sports ball.
It is sports ball. Well, he's a former quarterback, played for the University of Southern California. He then goes on, has a terrible NFL career, worthless, not necessarily worthless, but I guess Jets fans are never going to get very much in the way of happiness. Mark Sanchez, then he becomes a broadcaster and is involved in an altercation with a truck driver. And the original report makes it sound like Sanchez is the victim in this dispute. And then it starts to come out that maybe he wasn't the victim in the dispute. And then you see the photos of the truck driver. And now we've got criminal charges and civil complaint. That's one. Then we have Kouri Richins we're going to try and get caught up in what the hell is happening in that case. Because we've got the defense is accusing the prosecutor of withholding material. Prosecution is amending their charges. She's asking for bail, I think, third time again. And
keep asking, eventually they'll go to you, right?
You think so?
No.
Judge, they can't prove that I didn't do anything else. I mean, you're not going to get bail. It's been denied. And then she also wanted to expand the jury pool. The Supreme Judicial Court, the Supreme Court shoots that down. So that's story number, another story. And then there's a story that I didn't hear about, but my mods found. Do you remember the story of the Hatchet-Wielding Hitchhiker?
Yes, I heard about it.
You heard about the story, right?
Yeah.
Did you know, one, I didn't realize he actually later went on to unalive another dude, and was doing time for murder. So I didn't know that part of the story. But then, the behavior panel on YouTube, they did a video talking about one of his either interviews or his dialogues, and he took great offense to that video from behind bars, mind you, and filed a complaint for defamation against the behavior panel. Yeah. So that got dismissed, and then we'll do a little road so far on that one. I think I could probably find at least a little media clip from that old interview. But that's what we had on the docket for today. Realistically, there wasn't a whole lot. I know people were talking about the Karen Reed cell phone issue. I don't find that interesting at this point in time. It's the judge is all over the place. The Walshe case that we were covering, case Brian Walshe, who was supposed to go to trial beginning next week, basically, has been pushed because he is apparently now undergoing a competency evaluation. So I guess we can talk about that. So I guess we can talk about that. But don't fret, folks. Ian is staring at his computer because he's probably doing various things. I do see.
And he's also tired. It's been a week, man. Have there been any developments in the Janet case? Has she contacted you? Have you been named in any pleadings that you can tell us about since you put a thumbnail out that was a ruthless thumbnail? I mean, just wow. Please tell me you have that thumbnail saved so we can show it, because that was just. Oh, I'll have to dig that up. I mean, the thing about that thumbnail is she didn't want to be. What is it? She didn't want to be seen as what do you call it? Scary clowns or zombies or anything like that. So she insisted that it be something else. So, I mean, I'm obliging. Just try to pull this up here.
Yeah, the thumbnail is epic.
So give me 1 second. Let's see here. Oh yeah, Chad is also requesting a Potter update apparently. Yeah, that doesn't look like a really angry baby.
I mean, maybe it looks a little bit like a really angry baby.
No, not a little bit like a really. It looks identical to a really angry baby. Come on, that is a really angry baby. That's what that is. When I saw it, I was like, this is an angry baby, which makes sense. We're acting like children, but this is a solid angry baby photo. Also, looks like you just scolded the angry baby. Like, what did you do? Go in your corner. Don't want to hear from you right now, which I guess is maybe accurate. I'm not sure. I guess
I mean,
go with the toddler tantrums that are going on.
She did not succeed with her what is it? Well, she's still got the stalking no contact order in place, but it's not going to last from the judge's comments. So, yeah.
Yeah, it's
the judge's comments were basically, okay, I'm going to let you amend, but I need to see something to show a true threat, or else like incitement to harassment. And the one thing I always say is, don't reach out and contact people. Don't contact Janet for any reason, especially not if you need legal help. So
don't do that. Yeah, don't contact Janet. Like, please don't. We could do without any of that trouble being there.
So yeah, I don't think she's going to be able to meet the judge's requirements, and that should hopefully get the case punted.
One would think, but
one would hope.
There's a saying that I have. Niklas, I would love to hear about it. Actually, I don't mind. Let me see. If you want to give us an update on Gingras, let's do that. Let me see. I think I've got your contact info. It's late for you. We haven't talked in a while.
I mean, he's been saying that everyone's a cult for a long time. That's not new.
We're not a cult. I thought we were a cult.
Rob.
What? If we're not a cult, then why did I go out and get that really cool sweatshirt? And like 500 pounds of fruit punch mix.
Rob.
Is it bad to
Stop
admit
saying things that he's going to put into a filing as if they're like, as if they aren't sarcasm. He's going to put this down as like truthful.
He
will.
I don't mess with that dude. I don't know that dude. All I know is that his legal takes have been disastrous in almost every single respect that I've ever seen. It seems like it's like a clown show when it comes to anything having to do. He's like, First Amendment is, a suggestion. Maybe we should prosecute people who are not doing this stuff. Also, he represented one of the biggest liars that's ever existed. I just don't know that I've ever. Oh, look who was there. Look, it's almost as if you were by your computer waiting for an invite. How you doing, Niklas?
Hey, how are you doing? I haven't been here for over a year.
Really?
Yeah. But
That's
then
wild.
again, last time I was really, really drunk.
Dude,
now I'm only slight.
I think I do remember that. I do remember that.
I'm just slightly buzzed.
Everyone is saying, "Wait, did we get sweatshirts?" I don't know, Niklas. You've been following the channel for a while. Do you have a cult sweatshirt for the Law and Lumber cult?
No.
Just kidding. I'm just messing.
What?
I didn't mean to mess with you like that. How you doing? So what time it is right now? What time there? It is
3:22 a.m.
Oh, that sounds healthy.
No,
that sounds wonderful.
Now, I have the actual latest filing of David Gingras. I don't know how to pronounce his last name because I'm Swedish.
Neither does he, so it's all good.
Yeah, so Gingras.
Gingras?
I have
Is it Gingras? Did you just call him
ginger ass? I don't
ginger
know.
ass? We don't make fun of. We only lightly make fun of ginger colored hair here because I'm about to. I have ginger colored.
Before all this, I was kind of ginger, so I think I just burnt out, and yeah.
Well, I'm now outnumbered by gray-haired, long wizened people. You got gray hair 1, gray hair 2.
You'll survive.
Yeah, you'll do good. You'll do good. I've seen you have some gray streaks in your beard. I mean, you're getting there.
They're getting there, and it's. I don't like it every time. No, I think that's everyone else around here. So.
No.
But yeah, here I'll bring this up. You can show actually, you know what? Now we have to do a swoop because we're going to content. So you get to be swooped. We're swooping.
Yay! That's still the best swoop in the universe.
If no one else laughed when Nik was just like, woo! That's on you. If you guys don't find that funny, that's on you. That was great. All right, Nik. So give us a background. Give us a 5-minute TLDR, because people who are now watching this channel. So
there is no 5-minute TLDR here.
There's no such thing.
It might be more complicated.
Okay.
For those of you who are watching, before Nicholas goes into it, there's 1,300 of you. Hit the like button. I'm told that I wait way too long and I don't ask people to do it. Hit the like button on the stream and please subscribe. Please. So
yeah. First of all, for you who haven't seen me for some odd reason, hi, I'm Nik. I'm a labor lawyer out of Sweden, and sometimes they invite me and I invite them back. Laura Owens has a history for the last decade about faking pregnancies and filings. They are abusing me reports towards men who don't want to date her. And this now, finally, after about a decade, has reached the court. The courts say, hey, something's odd here. So in Arizona, they have now decided to charge her for 7 felonies of perjury, tampering with evidence, and other things. Despite this, she has now filed a permanent DVRO against Michael Maricini in California because he was subpoenaed as a witness in the Arizona case, and his attorney decided to bring this as a breach of DVRO in the California case, even though the judge told him explicitly in the Arizona case,
that issue.
Yeah, that no, he can be here. He has a legal subpoena. Despite this, David Gingras told the court. Sorry, my pronunciation is really.
I don't care. It's better that way. I don't care. From henceforth, he shall be known as David Gingras.
Despite this, he told the California court that Michael Maricini was there on an unlawful subpoena. Despite being told by the judge in the Arizona case, no, it's not.
Okay.
Since he now is a witness in the California case, the DVRO that is going from a temporary, they are now seeking a permanent DVRO. He is now a witness, so he can't represent Laura Owens.
Well, one would think, but
there are some discrepancies in this. So he now says that opposing counsel is lying in court filings.
Oh God!
And he does this by this very interesting court filing as an intervening party.
Oh, we actually have been talking about intervening parties. Ian has some experience trying to intervene in a case.
Yeah.
And then he was like, "You got it, guys. I'm going to see myself out."
Yeah. And from this, we found out from this particular that we are a cult.
Okay, so let's see. So that's the preview. So Laura Owens, from my recollection, she basically starts dating somebody that's significant, love bombs them, and then makes up that she's pregnant.
Yeah, with twins 3 times.
Yep, pregnant with twins 3 times. And then
despite claiming to have ovarian cancer, because apparently, and gulping down Monster energy drinks, gulping down Monster energy drinks, despite having this risky pregnancy, because she also claims she has other illnesses.
Yep. Yeah. And then claims that they were the victim of a domestic incident with the person they were with, right?
Yeah.
So and then she sues them, or she asks for some form of
DVROs,
support.
Yeah. Not spousal support, but DVROs, because for some odd reason she always terminates the pregnancy, even though there's no medical record of her doing that. Okay. And in the latest case against Clayton Eckert, who for some years ago was the Bachelor, in that court case, up until October of 2024, she claimed she was 100% pregnant with twins, his twins, until she realized in Arizona, if there is a spontaneous termination of pregnancy, you have to have a death certificate.
Interesting.
Yeah. So then her attorney, David Gingras, backtracked her spontaneous termination to just before that was a requirement in court filings. Hence, now being charged with perjury and tampering with evidence, because the doctors she claims she went to have never heard about her. Yeah.
I can see how that might present a problem.
But yeah. Somewhat.
So I have the filing, the request to renew the restraining order. You have is it a response? What do you have?
No, what I have here is non-party intervener David Gingras reply in support of his motion to leave to intervene for sanctions against opposing party.
Okay.
Yeah, because opposing party seek to disqualify him.
So let me get this right. So
it's dumber than you think. He is not the party. He briefly appears as the lawyer.
Attorney.
He gets contacted and is like, "Hey, you can't be the lawyer here." He's like, "I have no intention of being the lawyer," and they're like, "Okay, so we're gonna actually bring a motion to disqualify you." And he loses his mind over this because he's like, "Well, I said I wouldn't be the lawyer, but I still want to be the lawyer or to have that option."
He claimed. Well, his claim is in a 66-minute phone conversation. He told opposing counsel, "Oh, I will not represent Miss Owens."
Hang on, pause for a second. If I'm on the phone with opposing counsel for 66 minutes, we have problems.
Yeah,
that is not a short phone call.
No,
that's okay. So 66-minute phone call with opposing counsel, and he says in the end, at some point in the time of the phone call, "Don't worry, I'm not representing Laura Owens."
Opposing party emails him, "Through our conversation, will you tell us you will not represent Miss Owens?" And he then mails back, "Yes, I will not represent Miss Owens. But to be sure, Mr. Omar Serrato files with the court disqualification just in case because he only has the intent of not representing Miss Owens. So he wants to be sure he will not represent Miss Owens by asking the judge to disqualify him. Now, this has
Basically,
all
that might be premature though, right? If he hadn't known an appearance, wouldn't it be a little bit early for him to say, "Hey,
Yes,
judge,
and-
DQ him"?
He had made
Yeah.
an appearance,
Oh, he did,
but
So
he
wanted an
wasn't
appearance.
on record. He'd attended court as on one occasion. So they're
Yeah.
like,
Did he sit at counsel's table?
No, I don't remember the exact conditions, but in the facts of it, the judge did what you said. This is premature. So she denied without prejudice and more or less told the opposing counsel, if he tries, file it again. And this came today.
Oh,
that
I
decision.
love stuff like that. So the decision came today that, counsel, you're a little early in shooting off on this. He actually has a noted appearance before you can actually ask him to, be disqualified. He can be in the courtroom like a citizen, like a normal person. But okay, all right.
Yeah.
So context is given, and yes, to the chat. Mostly harmless Fair's does bring up a very important point. At one point, she actually backdated the loss of the twins to before she had filed a paternity suit against Eckert.
Yeah.
So, it's like which lie under that scenario, which lie is worse? Changing the date of the termination, the act of termination to before you filed the petition saying I would like child support for the children I just turned. There's nothing right about that change in timeline. So, classic.
I mean, she even submitted photos of the alleged spontaneous termination of the twins.
Okay.
Yeah, and she didn't seek medical attention after.
All right. So it's kind of a mess. So, but this is all of this is arising.
We are 27 minutes in. Let's just say it's a Foster clock.
That's fair. I like that. There is no way in hell I would ever pull off saying that the actual right way.
Yeah.
I would absolutely be saying
you cannot unf a cluster F.
Yeah. Okay.
Yeah. And by the way, I have the mug in my merch.
Oddly enough, there's an old restaurant called Fuddruckers. And there is. It's a restaurant called Fuddruckers, and I don't know why this just sparked a memory in my head, but when I was a kid, when kids there's a phase they go through where they kind of transpose words or multiple words, like it's a game they like to play. Well, I was at this stage of life, and I just started, just saying, well, it's red fuckers. And I was like, and I did not realize what I said until it actually came out of my mouth in a room full of adults that was otherwise very quiet. So maybe that's why that memory lives with me forever. But yes, so a flustercuck, is that what you called it?
A fusterclock.
A fustercluck. Got it.
Yeah.
All right. So
yeah,
I said it properly.
Okay, but this is the non-party interviewer David S. Gingras reply in motion of his motion to leave to interfere for sanctions, etc. Introductions. As everyone knows, motions for sanctions are common and they are routinely denied. I did not know this was common.
I already hate this man because of the next sentence. I really.
Yeah. In most cases, that's fair when lawyers doth protest too much.
So we're going Shakespearean in the second sentence, like immediately, or third sentence.
I mean, it's not so much Shakespearean as just moron, but
I'm with that one too. If I ever start writing like this, someone put me out of my fucking misery. Just please.
I will personally fly over there and smack you in the head with a chair if you put stuff in the filings.
I'm probably gonna do it next week too, just on accident. It'll probably like end up in a stupid email. Like some counsel's gonna piss me off, and I'll probably just say "thou doth protest too much," like in response. Oh God! And then it's gonna get called out in front of a judge. I can't wait. This is phenomenal. Okay. Yes.
Yeah.
Please proceed.
This case is very different. To understand why, this court needs to know about something called Justice for Clayton, or JFC. JFC is an online cult devoted to one single purpose, destroying the life of petitioner Laura Owens. By extension, the JFC cult is also obsessed with destroying the career of undersigned counsel.
Does anyone else know JFC is a different acronym?
No, you'll have to explain that.
Jesus fucking. You've never know. No. Like if you put JFC in the pleading, I'm not going with Justice for Clayton is my first thought process. So okay,
you haven't covered that case enough. And here's the next line: those allegations may sound paranoid, if not outright delusional. This is the only, this is the only line in this entire filing I agree with. It's unfortunately they are accurate and well supported. The JFC cult operates largely on social media. The cult maintains a Twitter account which has posted nearly 6,000 times about Miss Owens in the last 2 years.
I feel like those numbers are not that significant if you're talking 2 years.
It's not. It isn't. The cult also maintains an Instagram account, Justice for Clayton Official. Now, take a wild guess here if he actually connects these two accounts.
Probably not. I imagine these are just two separate people that have two entirely separate lives.
Yeah.
Yeah.
Yeah. And you would assume when you make this allegation that you put forward some evidence. This is the person.
No, I would not assume that he does that.
No. Not even close. Which is filled with the vile, cruel, disgusting personal attacks against Miss Owens, her family, undersigned counsel, and everyone who dares express the slightest degree of support for her. I've been looking at this case for about a year now. I have not to this date seen anyone in support of her. So,
I'm also looking at the Instagram account. It looks like half of it is just either court stuff or videos of her speaking, a couple of things here and there. But I'll also put it this way. If you falsely backdate the termination of twins that may or may not have existed, and where the court kind of found that they never existed and you lied about it, and you use that as an excuse, well, then you use that in a petition for paternity. I feel like you kind of brought this on yourself.
Yeah. Maybe.
Okay, so there's a cult.
Yeah. The JFC cult thrives on inhumane cruelty. One of their favorite pleasures is attacking Miss Owens' physical appearance. The sick individual operating the JFC Instagram account routinely posts images hundreds of times each week. No. By the way, no. Depicting Miss Owens as a hideously deformed creature, Gollum from Lord of the Rings.
Sorry, the laugh was involuntary. I did not know that those pictures were coming.
Poor Gollum. Poor Gollum.
Also, I fucking hate Chucky. I was scared shitless of that as a kid. Keep going. Sorry.
Yeah, I'm just feeling sorry for Gollum here. I mean,
yeah.
What does this have to do with the issue of sanctions? Here's what Respondents Counsel Omar Serrano is a prominent supporter of and participant in the JFC cult. More than that, Mr. Serrano is also friends with and frequently collaborates with a key cult leader and instigator named Lauren Needy. Now, I've been on stream with Lauren. She is the nicest person you will ever meet. Now, she does cover this case, but she mostly covers other cases. It's like what most of us do.
Yeah,
if something
talking about
interesting or
irrelevant.
stupid, if something interesting or stupid is filed, we will read it. And with David Gingras, that's every one of his filings are either stupid or funny. Or Mr. Gingras, we're not laughing with you, we're laughing at you.
I'm just laughing at the pleading right now. I'll laugh at you later when I find out. Well, you know what? Doth protest too much. I'm laughing at you.
Below is a recent photo of Miss Needy and Mr. Starow appearing together at an event in Arizona. Do you see in the background if it says Owens versus anything, or if it's an entirely different case?
Yeah, it looks like it's talking about the Justin Baldoni case, Blake Lively.
Yeah. It's almost as if he didn't check the background of the picture in his filing. Because
suggest as much.
Yeah. If the name Lauren Needy, I'm sorry, Lauren, I don't know how to pronounce your last name either. Sounds familiar? It should. On July 11th, 2 days after this case was filed, Miss Needy filed a media request to broadcast this entire case. The court denied that request the same day it was made. Mr. Needy is not associated with any legitimate media outlet. First of all, I think that ruling is a pile of garbage. Because...
Oh, is that what the ruling said?
Yeah.
Oh, then the judge is wrong.
Yeah. You don't have to be associated with either NBC, Fox, whatever, Court TV or anything. If your purpose is to report, you're a reporter. And folks, I'm not American, but the freedom of the press is the literal freedom of the printing press, the medium, not the individual. Which means YouTube, newspapers, radio, if anybody uses that anymore, it's the medium that is the freedom of the press, not the individual. When the freedom of the press doctrine was introduced, there was no journalist school.
That's absolutely correct.
That is my understanding. So but this stuff happens many times, sadly, that judges say, well, you're not a part of this legitimate media. And it's bullcrap.
I would agree with you.
Yeah,
but
so sadly...
but then the friendship, he says that there's friends, great, but the friendship is not the reason why. So why mention the friendship?
Exactly. She's simply a YouTuber like Mr. Serrano. Well, Mr. Serrano is a licensed attorney. So, yeah. The friendship between Miss Needy and Mr. Starow is not the reason why sanctions are appropriate. Rather, sanctions are appropriate because Mr. Starow filed a groundless pleading, his motion to disqualify, which contained false and disparaging statements about the undersigned made solely to harass. But there's more. Like this pleading is a fucking commercial.
Oh my.
Sorry.
You don't have to apologize. You're fine. You're warranted.
At the time that motion, at the time the motion was filed, Mr. Starow knew it served no legitimate purpose. According to who? Mr. Starow knew the attorney-client relationship with Miss Owens was voluntarily terminated, even though there was no ethical requirement to do so. Spoiler, there was, and there is, because he's a witness in the hearing. Now, to my understanding, California has exceptions to that an attorney can actually testify and represent their client. But I don't think that applies here.
I can tell you, California might have that rule, but I think that ethical guidelines is a problem.
Yeah.
But so where is keep going? So I want to make sure we get through.
Even though blah blah blah, the relationship was terminated in part to keep this matter simple and to ensure the parties and the court would not waste time dealing with unnecessary collateral disputes. So why the flaming fuck are you filing this garbage? If you claim I voluntarily pull myself out of it, all you had to do was say, I don't agree with the content, but I will still ask the court to disqualify me. It's a 3-line motion. This is not a 3-line filing.
No. Keep on scrolling.
But Mr. Starow and Ms. Needy need collateral disputes. Why? Because collateral disputes provide content for Ms. Needy's YouTube videos, and every new video means more money. And that is exactly what has occurred. For those interested, she covered this case, but she doesn't actually make especially amount of money. She makes substantially more money out of the Blake Lively case.
Believable.
But this case, because Mr. Gingras keeps filing garbage, she reads it.
Well, hang on. So what is he saying that the defamatory statements? I'm just reading. So he's saying that Ms. Needy has released hours of videos talking about this case and gloating about Starow, roasted and embarrassed at the undersigned in his pleadings, including his motion to disqualify. In the videos, he repeats every false and defamatory statement contained in the pleadings while soliciting money for her efforts. No, she's reading
the filings.
Oh, okay.
Yeah.
All right. That's sure. Why not?
And Mr. Starow, when he files his opinion to the court to disqualify, now this was deemed premature, so it was denied without prejudice, so he can still refile it if necessary. But according to Mr. Gingras, they are in cahoots with each other, so these filings of Mr. Starow is so Miss Needy can make money out of it. Because we're a cult.
I get it. So the filings are happening to create the YouTube content. The YouTube content is happening to create the filings. Chicken, egg, that logic. I'm with you. Okay.
Yeah. In addition to disparaging Miss Owens and undersigned Miss Needy has posted videos praising Mr. Starow for his valiant battle against Miss Owens in this case. In his opposition, Mr. Starow never denies collaborating with Ms. Needy to attack Miss Owens and to further the JFC cult's goals. What is there to deny if it's manically
it doesn't matter.
Opinionated?
And why does it matter? You can accuse me of something, it just doesn't matter.
Yeah, but you can opine, but it doesn't make it true unless you have actual evidence of this. And spoiler, he doesn't produce evidence. Instead, he attempts to downplay the issue, suggest Gingras' theory that Mr. Starow filed the motion to disqualify to create YouTube content is unsupported and unreasonable. Starow filed one motion on a serious issue and has not created any content related to Owens and Gingras since entering this case in August of 2025. Yeah, Mr. Omar, before he represented Mr. Maricini, he covered the case.
But I thought this was... Is he going to get to sanctions or any of the issues about sanctions? Like, does he get there?
No.
Okay. So
he opines about it.
Okay.
He opines about it, but basically, for instance, Mr. Gingras has posted a lot of content, videos. He's on Blue Sky, he's on X, talking about this case while representing Miss Owens. The moment Omar started representing Mr. Maracini, gone. No more content. Who's the ethical one? According to Mr. What are you doing, Mr. Jingles? What have you found? Sorry. Mr. Jingles is under my desk playing with something I hope is not a prey.
We shall see. I'm looking for the pleadings on the side. So we keep on going. The new content's being created.
This argument misses the point. Regardless of Mr. Serrato has paused his YouTube career, his long-time collaborator, which he produces no evidence of, Miss Needy has not. Instead, she continues to create new content about this case virtually every single day. No, she does not. She produces content when you, Mr. Gingras, write something stupid, which happens to be every time you write something. Because Miss Needy keeps posting the same disparaging content Mr. Serrato previously did, their plan is obvious. They intend to use this case as a platform for generating and publishing false and defamatory statements in pleadings, which are privileged and protected.
Yeah,
so Miss
pleadings. Go ahead.
So Miss Needy can then profit by republishing those lies on her YouTube channel. These are public court filings, and she reads them. There's actually not.
It's also like, what is your actual stake in this, dude? You're not a party here.
That's what I'm not understanding, is where he gets to any particular sanctions. He's just yelling.
Yeah, I mean, he is trying to intervene because he's a witness, and he files this and he makes statements. Whether or not he is actually producing evidence to this, no. I don't think he does. While that claim might sound paranoid in any other context, it does. The court must understand Miss Needy has demonstrated a willingness to do absolutely anything, legal or illegal, to attack, defame, and harass both Miss Owens and the undersigned.
Okay.
Is he accusing Lauren of a crime?
He's
not accusing her of a specific crime, so it's not going to be defamatory because it's not specific enough.
Yeah.
So,
but he's kind of getting there. We're not done yet.
Yeah.
She's engaged in such conduct nearly every day for almost 2 years, which is false. Again, examples are too numerous to include them all, which for me says you really can't find examples.
How about like a greatest hits?
Yeah, and there are non-existent apparently. So just consider this. Miss Needy recently created a social media profile using the name David Gingras, accompanied by a photo of undersigned counsel's face photoshopped onto Miss Owens' body, which is insanely funny. Using that account, she spends hours each day posting comments in the name of David Gingras, including this fine work of poetry. Guess if he actually have evidence that this is Lauren doing this.
None whatsoever. I'm imagining.
Zero. Nothing. Now, this is funny. I must admit, this is actually quite funny. Is Mr. Serrato liable for the criminal conduct of his friend, Mr. Needy? Let's see.
I need to see that footnote.
is both a tort and a crime in the state of California for any person to knowingly and without consent credibly impersonate another actual person.
It's a clear satirical post, you moron.
And it seems like, here's the thing, because without consent, he underlined the wrong part, because the credibly is actually doing some work here. Like, that is the part you actually have to like be attempting to actually impersonate somebody. So
yeah,
that's just really stupid. Okay, sure, why not? Go on.
And he doesn't actually provide proof that Lauren is actually behind that account. So, all right. He will claim he is not, but when two parties conspire to engage in unlawful conduct, both may be held liable for the other's illegal act. See,
why does any of that, literally, why does any of that matter? The insinuation is all there, but tell me why. Okay, sorry, keep going.
I wish I had an answer. And it said, noting in a civil conspiracy, quote, each member may be held jointly liable as a tortfeasor, even though he or she may not have participated directly in the underlying tort. Now, this case,
yeah,
he actually doesn't quote from the case.
He's quoting from a case that the case cites?
He doesn't quote from the case site.
Got it.
There's noting in a civil conspiracy, he quotes from something in... Yeah, I can't find the exact quote, but this is basically...
Which one are you looking at? Because there's multiple...
Yeah.
There's multiple citations there.
But I don't find it. This quote is not from that case.
Which one? There's two.
Which,
it looks like
only one case. It's one case.
No, it's one complicated case, right?
Yeah, it's one longer name.
Yeah,
that's what it is.
Yeah, but his parenthesis is noting in a civil conspiracy. So I believe this is from the law, not from the case law. Because I didn't find this quote in this case. California Appellate Court 4th 1105-1136.
I don't know that that's going to be the most relevant thing. I think it's what I'm looking for.
Yeah,
Nick, do you have
there.
That quote is in there?
It's under
it's in
J.
there.
This is thank you. I didn't shit, I didn't find it.
The quote is in there.
So okay, so I'm looking. Nick, do you have the link to the actual PDF?
Rob, you're muted.
No, he isn't.
Oh,
I hear him.
Or I just can't hear anything from you guys. I don't know.
Either your audio might be down, but
my
Nick,
audio
do you
is
have
down.
Yeah. Do you have the link to the actual PDF that you're looking at?
I don't.
Let me see.
Have you asked me 6 hours ago? I had, but I.
I'm looking at his affidavit because I see that he filed an affidavit. And then there was. Let's see. I'm looking for various things for the actual filing because I want to scan it real quick.
Plaintiff's home was severely damaged in the 1994 Northeast earthquake. Okay.
Yeah, but why is any of that? So scroll down. So the truth is, there's no question he filed groundless pleading, which contains knowingly false and disparaging comments. Which ones? Keep going. No question he did so for no valid reason because he knew the attorney-client was voluntarily terminated.
Down in J. Every cause of action, civil conspiracy to commit intentional fraud, and 12th cause of action, civil conspiracy to commit conversion.
Nick, you've gone ADHD mode.
What?
I need focus. I need focus. Wait, let's go back to the actual pleading. Scroll down a bit. I want to keep going on the pleading.
Oh, pleading. Sorry. The truth is this: there is no question Mr. Starow filed a groundless pleading which contains knowingly false and disparaging statements. There's no question he did so for no valid reason, because he knew the attorney-client relationship was voluntarily terminated before the motion was filed. Yeah, but it wasn't filed with the court. So what you say, Mr. Gingras, is your intention is to not represent Miss Owens. That does not mean you don't plan to do that, which I believe is why they sought the disqualification beforehand.
Yeah,
because they can't trust his word for it. And now the judge deemed it premature. If he tries, file it again. But if he says he doesn't do it, doesn't intend to do it, and he doesn't, then this is moot.
So
But
pleading was turned into a lengthy YouTube video.
But the claim here, knowingly false and disparaging, no, he's just trying to make sure. That is not knowingly false, in my opinion, at least.
YouTube video. Given the history of extreme hostility shown by the extreme hostility. So scroll down. The only question is whether the court believes the conduct is acceptable. He hasn't said any conduct yet. You've just talked about things outside of court.
Yeah.
Scroll down. Owes the duty of the honor of the law and well, that seems like it would need a citation if you wanted to say that. Should send a clear message. So please send a clear. Practicing law is not the same as making YouTube videos insulting other people. Really? I thought it was.
He wants to hold Starow liable for
YouTube.
Needy without any actual connection to Needy. So
yeah,
it's
but we're a cult, you know.
Bullshit.
We're a cult, apparently.
Okay.
I talked to Megan Fox, and we are thinking of calling it the Golden Cahoots or something of the Golden Cahoots social cult.
Okay.
But we are not sure yet.
I'll let you decide on the name. How about you stick with you do that one? Okay, let's see. So keep scrolling. So he's citing YouTube's terms of service. This is going to work great. Awesome. Discussion. The pleadings speak for themselves. As such, only a few points will be mentioned. Well, if the pleadings speak for themselves, and why that's stupid. Keep scrolling. He argues the court cannot grant leave for the other side to intervene. Other side reminds the court they filed a motion seeking to disqualify. That motion was based on a lie. That doesn't mean you get to intervene. You're not a party to the case. They can say whatever the fuck they want about you in a pleading. If that lie was true, there'd be no need to intervene. There's no need to intervene. You don't have a base to intervene because he said something in a pleading. Shut up. Sanctions could and would have been requested as Owens' current counsel. Why would that's also dumb. Let's see. Representation, of course, is false. He knew the attorney-client relationship ended before his motion was filed. How the fuck is he supposed to know that? You just because you said it, he's going to take you at your word?
Yeah,
like that.
But there's no transcript of that phone conversation. So
well, and at the end of the day, all of this is just stupid. Just because it's like, all right, so your feelings are hurt and you want sanctions, but you're not a fucking party.
Yeah, I get you're upset, like you're angry, and I understand why someone would be angry at certain times. Holy shit! Hang on, he really filed a.
It's a motion for hurt feelings.
So yeah, it really does look like one. Scroll down. So he talks about different violations of the code. This is a reply. How many fucking pages have they spent on this crap? Let me do this. Give me 1 second. There's this same 12-page document. Yeah. Let me pull this down.
Spent implies that he's like actually getting something for his effort.
Oh, we haven't gotten to when he when he compares Laura Owens to Charlie Kirk.
No, so well, that's a decision.
So all of this is over. All of this is over for the motion to intervene, for sanctions, and for disciplinary referral and all the other stuff. So that pleading that you had up was how many pages?
12.
12 pages. This is his declaration in support of that pleading that he also filed, which is also, oddly enough, 12 pages, and goes on and talks about my work in this case and yada yada after reviewing the questions. Shortly after the video, there's another video that was posted. These people are generally not interested in the truth. I'm pretty sure that they followed this case because they were interested in the truth, namely that your client's a fucking liar. Interested in creating a self-serving narrative they believe will be most attractive to whatever audience they're focused on. You mean following a case that's somewhat interesting, like someone who would fake a pregnancy, or fake the termination of a pregnancy that was a fake pregnancy? That sounds to me like an interesting case.
Yeah.
He's basically Janet.
It's like, I don't know who's worse. What if they mated? That sounds horrible. Imagine the spawn of that unholy union. No, we shall not. Several days later, I had the lengthy phone call. The call lasted 66 minutes. Now, based on how this dude writes, I can see how the phone call lasts 66 minutes. God, there was a joke that followed that I probably shouldn't have said. Seeing how this dude writes, how this dude argues,
be glad he didn't say 69 minutes.
No, it wasn't that. I was just saying it's probably the only thing that lasts 66 minutes in any given day or evening that he's had in a long time. So, I mean, this word count's really, bringing home the bacon and making everyone happy. And yeah, sure. During that discussion, Mr. Starow and Ms. Juarez told me they believed I should not continue to represent them for various reasons. All right. Among other things, they argued I had a present conflict of interest because last year, Ms. Maricini filed a complaint against me with the State Bar of Arizona, which related to the same issue. It wasn't just that Maricini that filed the complaint. Didn't the judge refer him to the bar?
Judge referred him to the State Bar as well. Because Mr. Gingras took notice that the judge's father was in attendance one of these days. So in his plea filings, he wrote, and I believe this quote is correct, "Hey, Daddy, look at me. I'm a real judge now."
Due to immediate attention. So this is the State Bar complaint or the referral from the judge. Judge Mata refers to the complaint. This is about this incident, attempting to have the Michael Maricini arrested, valid subpoena, unable to find the witness tampering. Strongly appears to be an attempt to prevent his testimony by counsel.
Yeah.
Cross-examination. Ian, your mute button is actually showing his.
No, I was unfucking my mic, but you left out the key part of his quote, which was, "Look, Daddy, I'm a real judge now. Tee hee."
Oh yeah.
Oh yeah. Okay.
And he put that in quotation.
Oh, so the judge actually puts so Gingras sends the judge an email, writing to raise potential urgent issue. Okay. It's quite bold of you to email a judge with all that crap. Or was this to?
For no apparent reason. Did you know that David Gingras had recently had his second DUI? 3 minutes from Laura Owens' residence.
Oh, this was it. Here was the quote. So where it was my case fairly decided based on the evidence, or Judge Mata simply trying to impress her father? Look at me, Daddy, I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. He. Yeah. So that's the referral by the judge for a bar complaint. So I don't know that it's simply limited to Mr. Starow or anyone else. I mean, or Maricini filing the bar complaint.
Mr. Gingras conveniently forgets some facts.
I mean, Gingras also says, he said, I told Mr. Starow I strongly disagreed with his analysis. Well, let me tell you how much great weight I give that. You just got called to task by the judge that overheard the case after you sent an email to the division of the judge. Are you kidding me? You're lucky you're practicing law at all.
Without belaboring the details, I explained that it's no conflict at all between myself and Ms. Owens with respect to this case. On the contrary, I saw our interests as entirely aligned and consistent, not in conflict. That is not what conflict of interest means. That is the opposite.
In fact, if your interests are too aligned, it can still be a conflict.
Isn't that actually kind of the definition of creating a conflict, where your interests are intertwined?
Yeah.
I think he's sir, you do recognize what conflict of interest means, right? Like the actual.
No, he does not recognize anything.
No.
So he thinks that conflict of interest means that he is somehow has to be adverse to his client. Oh, that's an interesting take. Sure. The bottom line is, I firmly believe that Mr. Mancini broke the law. He committed a crime and he violated the court's order to such an extent that the relief is factually and legally proper. Well, that's cool. I'm glad you believe that.
The judge in Arizona is dumber than dill pickle flavored nails. It's
the judge didn't agree in the Arizona case. The cops didn't agree with him in the Arizona case. But he's still filing with the California case as if that subpoena was illegal.
Here's the other thing. This also tells you you're a joke as a lawyer. I'm sorry. I'm going to go out on the record and say that I believe Mr. Mancini has committed a further federal criminal act in violation of 18 USC 1513E, which provides, and he quotes it, and then he cites the quote as being from law.cornell.edu, U.S. Code Text 181513. Are you kidding me? That's not how you cite a code section. Like, that's not how you do that. And you don't cite Cornell's website and their version of the code. You actually cite the code section like as if you actually looked it up. What the fuck is that? I firmly rejected the argument that it would be unethical or improper for me to continue representing her in this matter. Nevertheless, in an abundance of caution and with the goal of reducing, David, I believe that your goal is in reducing the contentiousness of this case. 12 pages plus 12 pages plus more pages makes me very firmly resound in my agreement that you are intending to reduce the contentiousness of this case, asshole. After discussing the situation with Laura, I decided I would continue to participate in this matter as a supporting witness. What? Wait, what? You said it. You said the words. You said supporting witness.
Yeah.
You put it in your pleading. You're an idiot.
Yeah.
Okay.
Oh, I mean, if I'm the judge, I'm just like, this is going away.
Yeah. By the way,
solid burn.
Yeah. This filing of Mr. Gingras was denied.
Yeah, I believe it.
Yeah.
But then he does this quote. You know what? This is a lot of effort. This is a lot. He typed a whole lot of words and put it into a pleading and gathered documents and screenshots. This is like,
and he really ought not to have.
He really shouldn't have. Lady Fang says Gingras is what you get when you order Janet on Temu. I don't know. This is just. I might disagree with that assessment a little bit. Let me tell you that how much this would cost if this was something I drafted.
What it would cost to get me to file this?
Oh no, I mean just the hours spent in drafting something like this. You had to figure that he spent at least an hour and a half drafting this, right?
Sure. And the thing is it's one thing to add up the cost it would take to draft this. It's another thing to be like, to file this, the amount of money that you would require to convince me that this needed to be filed is all the fucking money.
No, I don't know that it's there. This is just okay. So this guy has now made himself the star of the show. I love it phenomenally. So he says in this email, the email says, David, do you mind sending a quick email verifying and writing you're not going to represent Laura? Yeah, that sounds pretty smart to me after the conversation. I would very much like that. I immediately responded to the requested email shown below. Wait, this is not this could have been a one-liner there. I don't know that you needed to go this far. Yes, this confirms, as we discussed on the phone, I'm not going to represent Laura any further in the Mancini matter in San Francisco. As we also discussed, despite the single appearance I already did in the Mancini matter, my notice of appearance was somehow rejected by the court for technical reasons. Thus, the docket does not show me as Laura's counsel of record. Because I'm not counsel of record, I do not believe I need to formally withdraw since I've not yet formally appeared. That's playing a game that I don't think I would ever play. I would never play that game in court.
I mean, I can tell you how I'd respond to this. Can counsel seeks to disqualify me. I have no interest in appearing as counsel on this matter.
Yeah.
I do not oppose their motion for disqualification. Or you might say, well, I disagree with their basis for the motion to disqualify. I'm happy to enter a consent disqualification.
Yeah.
Done.
It's a
Dusted.
3-line response that he needed to do. He made a 12-page.
He didn't even need to do a 3-line response.
It's more than
What
12
he could have
pages.
he could have just done is said, I am not counsel. I take no position.
Yeah.
One line.
Well, and
Done.
it was a 1-line email. So then you don't need my permission. You can contact Laura directly as needed moving forward. Sure, why not? Mostly harmless fuzzball. This is a lot of work for him not being Laura Owens' attorney. I'll tell you that this would probably cost about $800-900 just to draft the stupid thing to a client. And that's just this document. This is on this. Well, that's what I mean. That's without me looking up any of the stuff. This is 12 pages. That is a reply. This is the declaration in support of the reply. So there was a reply that was filed. There's the declaration in support of the reply. The fact that there's a reply indicates that there was a response that was filed by the other side, which was in response to his underlying motion. So you have the motion, you have his reply, and you have the affidavit in support of the reply. And that's just the starter. So
yeah,
I know Laura represented in this matter.
Grand worth of bullshit.
Then and a few minutes later, he says a reply saying, "Thank you. Sure. Awesome. Love it. Based on these events, I was shocked when I learned that they filed a motion to disqualify from acting as counsel in the case." Well, I wouldn't take offense to that. I also don't want to burden this court with needless motion practice. Oh, sir. I did not want to burden this court with needless motions practice over the propriety of our participation.
Oh,
as you didn't.
Yeah, Mr. Gingras does not want to burden the court.
You filed the motion. The simple fact is that regardless of whether I act as Laura's counsel of record, I'm still a participating witness in this case. No.
Yeah, those are two very different things.
You don't get to do both. You put them in the same sentence. Like you put them right next to each other. You can't do both of those things.
Oh,
like the simple fact is that regardless of whether I act as Laura's counsel of record, I'm still a percipient witness in this case. Well, that's not how that works. Like those are in opposite. You can't be both. I can and will tell this court what I saw and will test. Nope. That part. You can't do that part. That's a witness. I will testify about the events leading up to this point. No, you don't get to do that if you're the lawyer. For that reason, I did not think remaining as Laura's counsel of record was sufficiently important to justify challenging Mr. Serrato's position, even though I disagree with it. How the fuck does that make any sense? Let me tell you what's the stronger place. Ian, if you had to oppose someone's position or someone's factual assertion, do you think the stronger position would be to be the lawyer who can file shit or the witness who has to wait till a question is asked of them? Which one would you choose to be?
I would choose to be way far away from this.
That's the logical choice.
Now, if you're a Gingras, yeah, I don't know. I mean, it's so much garbage in this filing.
This is the declaration.
Yeah.
So he's posted more than 400 videos on his channel. Okay.
Yeah, and in the midst of all of this, he posts videos on his own channel. He comments on Blue Sky and on X. Now he deletes it afterwards. But he does that all the damn time. And he still has the audacity to say, Omar is the unethical one?
I have litigated cases before the California Court of Appeal, as well as appearing on behalf of amicus curiae of the California Supreme Court. I've obtained multiple favorable published decisions from state and federal trial and appellate courts across the country.
I had this rant before. If you have to say, in my 25 years of practice, what you should say is, I am actually being a fucking clown, because if you have an argument, you do not go with my 25 years of practice. That's loser talk. That is, I suck at my job and I need to put some loser bullshit in this.
Let me tell you this. The other part about it is I've worked on a number of, when you're saying I've worked on a number of very important cases in both state and federal court, many of which were extremely contentious. If you have to say these things, it is very likely just not true. Like
if the court already knows your reputation,
yeah,
great. If the court doesn't know your reputation, you're not going to be able to convince them you've got one.
Yeah. Now he's been.
You can't wish a reputation.
Is this in federal court?
No,
it's state court.
Yeah.
It is state court. So when pursuant to 28 USC 1746, I declare independently of perjury under the laws of the United States of America, state of Arizona, the foreign.
Oh, dude.
Why did
not fucking do that? You've already got you already got your client dinged on perjury charges. My dude, you should not be signing anything under penalty of perjury.
Ian,
you should be hiding under a rock under penalty of maybe the sunlight will,
But to be fair, the statement of "look at me, I'm special, I'm a really good attorney and very important" sounds a lot like opinion, and I don't know that I could prove that as being demonstrably false.
I don't know about that.
I mean, in his head, he might have believed it to be true. I think
I will accept, but that is totally demonstrably false. Being a good lawyer.
Yeah, I don't think that's not how that goes. That's a sworn statement. So that's the declaration. So you have the declaration, the motion, everything else involved with it. What the fuck?
Yeah,
that's something else. That really is.
And also Laura Owens. Laura Owens asked for a continuance from the October 2021 hearing of the permanent DVRO because she doesn't have a lawyer. Now, she found out she doesn't have a lawyer on August 22nd. She started looking for a free lawyer October 1st.
I would not work for her I want to set up my practice to be pro bono law. Yeah. And I can tell you, I would not work for her for free. I would not work for her for money. I would not work for her full fucking stuff.
Yeah. Would you not eat the green eggs and ham here or there either?
Yeah. On October 6th, she called opposing counsel to ask for a continuance. And on October 7th, she filed with the court, please 45 days continuance. That was denied.
All of this for an extension of a domestic violence protective order?
Yeah.
All of this litigation, every ounce of this is to extend a protective order?
Yeah.
Yes.
Now, the speculation here is that she tried to use this DVRO in order to get something for her in the criminal case in Arizona.
This is...
I think it backfired.
I would say I don't know that I would. I don't know that I would say that. Here's the other part about this. You have a judicial finding that you lied. You have a judicial finding that says you're a liar. Not only that, but you have a judicial finding that says you're a liar as it relates to a statement that you are pregnant.
Yeah.
And a statement that you terminated a pregnancy. So you have a judge finding on the record you have lied about your own medical circumstances. You know what you probably shouldn't do? File a declaration. Well, file a declaration with this court on October 7th.
This is glorious.
File a declaration in this court saying that your father has a medical hospitalization that requires assistant care. Okay, if that's true, I'm very sorry. I've also been advised to receive urgent evaluation and treatment for gastrointestinal bleeding, and I'm undergoing ongoing medical testing and care.
Guess if she actually filed her medical.
Well, I
papers.
would never want someone to have to do that. But here's the thing: you have a finding in an Arizona court that you lied about receiving medical treatment.
Yeah.
But then you're filing a pleading, like
because of medical
right
reasons.
on the backs of that, right on the back of that. You're citing medical treatment and medical condition. Every one of these law firms is like, please leave me out of this. So I've been trying to contact and secure representation, contact the Bar Association, Law Referral Service, contacted all for the Family Legal Clinic. Found indigent by an Arizona court, which affects my ability to retain private counsel immediately. What? That shouldn't at all. Long case.
But where's the reply from them? I mean, she says they replied with 2 to 4 weeks. Do we trust
private
her?
counsel will often not sign up for you being, if you're listed as indigent, they're probably not going to sign up to
jump on it and represent you. Yeah.
Now, here's a question I've been waiting to ask Rob for some time. Rob,
Please.
you have done bankruptcy cases,
bankruptcy and domestic relations protective orders.
Yeah,
like this is my wheelhouse.
Now, Laura Owens, in this criminal matter, has a high-end attorney paid by her attorneys, by her parents.
You're not calling David Gingras a high-end
No.
attorney.
David Gingras is nowhere near this criminal matter. Nowhere near it. So her parents hired a high-end attorney, paid him a retainer, and a few weeks later, they filed for bankruptcy.
The parents did.
Yeah. Now, in the bankruptcy case, they are 2.3 million in debt.
Ouch. That hurts.
Yeah.
Sounds like time for a clawback.
That's my question.
That's
my question. Because her criminal case is not related to her parents. If they paid her attorney $100,000 allegedly in a retainer.
No, that's here. It's different than what you're thinking. I'll tell you what it is. It's not. So every now and then, I will have a client that will contact me and they'll say, "I'm going to file bankruptcy." It's fine. And then I have to give them the speech, which is basically saying, look, within the 90-day window before you're filing, the assumption is that you're going to be filing bankruptcy. So don't incur any further debt prior to filing bankruptcy, right? You cannot incur debt with the understanding that you are seeking to discharge that in the future. It's bad faith. The court, they view these time windows and certain actions taken place in these time windows as demonstrative of whether you are engaging in a bad faith effort to essentially commit bankruptcy fraud. And you can get your Chapter 7 kicked out, dismissed. You can get a discharge denied, which is almost like worse. Like if you have your case dismissed, then you can file it again unless it's with prejudice. In a bankruptcy case, you can usually get that done quite often. If instead of the court seeking or allowing the dismissal, if they say, we are going to allow you to continue the bankruptcy and we're not going to let you out of it, we're just going to deny your ability to get a discharge. That's even worse because they have just made that debt non-dischargeable. So hypothetically speaking, let's say the parents didn't have any money. Let's say they didn't have any cash and there was no money that they actually gave away. Let's say, hypothetically speaking, they went and they got a loan and they took a loan with the understanding that they're already $1.8 million in debt. So what's $100,000 loan that they're going to discharge anyway. So they take that loan and they use the money from the loan and they pay the loan to Laura Owens for the law firm, or they pay it to the lawyer, and then they file bankruptcy to discharge the loan they took out. So realistically, the creditor is the one who's pissed. I think the parents probably face a situation where they're not going to be able to get their discharge. And honestly, I think the creditor or the trustee might start poking around.
Rob, you've got to be careful with your language because this whole case starts with Laura Owens getting a discharge. So,
oh, well, the discharge from what I heard was not capable of actually creating children. I heard the discharge occurred above the waist, perhaps above the neck.
It was not a discharge in bankruptcy. Let's go with that.
It was not a bankruptcy discharge. It was not. However, that particular type of discharge can lead people to filing bankruptcy down the road because kids are expensive as hell.
She's
Also true.
35 years old.
Okay. I'm not going to shame people based on their age. I'll shame people based on the fact they're fucking liars.
Yeah, that's
I'll stick with that.
Never had a job in her entire life. But the thing, my question is, if they paid a retainer of allegedly $100,000 to her criminal attorney, and then immediately or within weeks filed for bankruptcy, can the creditors claw back that retainer?
It is possible. The question is, the judgment would go as to the attorneys. So the attorneys would. I don't know that you would actually want. I'm never going to fault an attorney for litigating a case, being paid to litigate a case. Your job is to be a zealous advocate for your client.
No,
I will have an issue with an attorney that's like, it just seems to want to become a part of the case. I also will have an issue when any attorney, as I don't know why I missed this before, but when they actually put their fucking picture as in the email heading, like, are there any other attorneys that do that? If you're not a public facing figure, lawyers in the chat, do any of you in your Outlook have your photograph like there so that when you send an email to somebody, your photo shows up?
No,
I don't think I've ever done that. That's just very, very odd. Anyways, I'll make fun of attorneys for doing stupid shit like that.
But by the way, have you seen the January 29th raid of the home?
I did. I saw something scrolling through that actually occurred. So someone raided the home.
Oh yeah,
she got a raid on her property.
Yeah, the home and it's bad.
Well,
the cops are extremely.
I mean, it's not super terrible. It's just the cops have to walk her through, like, hey, this is not optional.
Yeah,
like we are actually.
I want to call my lawyer, and that's David Gingras, who says comply with them.
And I will give him credit for that, because that is the correct response.
Yeah, that's absolutely the correct response. And
and she's also. This is also. Isn't she facing 7 felony counts?
7 felony counts.
Okay.
Let's see. Oh, where is it?
It's a mess. This is a mess.
It's a clusterfuck.
Why? Every now and then I look at cases and it's people look at me, the family lawyer, and they're like, I could never practice family law. I could never practice family law. I deal with some contentious cases. But I'm going to take that back. I'm also not going to curse myself. I'm not going to curse myself because somehow I will end up, if I say those words, I will end up with some jackass attorney on the other side of the aisle that files these 20-page motions, and I'll have to deal with that. So
you're going to end up with Gingras.
Yeah.
Oh my god.
Okay.
They just make it a nightmare.
I have the raid lined up here if you want to see it.
I've got it, Nick. I don't know that I want to go into that too much because I still have to make it through 3 other topics this evening. So the Gingras thing was a side venture that I didn't know was going to be as eventful.
You're welcome.
Thank you. I don't know if I needed that. I don't know if I needed that level of chaos in my life. I mean, that makes my week. Maybe it does. It makes my week feel better. Like I'm not dealing with that crap. So I don't know.
The Laura Owens case in its entirety is an utter and complete clusterfuck.
Well, yeah.
And I just skimmed the outside of that. I mean, Megan Fox have much more content about it. And here's the thing. Clayton Eckert, the last one she tried to scam, he says he is prepared to, if I remember correctly here, because he believes that the person doing all of this is her mother.
Okay.
So if Laura Owens just admits to, yeah, I fucked up, but this is why, he would actually support her.
What sounds? I don't like this. This case is just stupid. That's
Yeah.
I don't.
I mean,
I get when people get contested and they litigate all types of crap. I really do understand why some cases have to go to trial. Because some cases you're just never going to get an agreement. I understand that part. That I can accept. What I have difficulty with is looking at cases that it's like, was there a legitimate purpose to filing anything you filed? It's like the Billy Madison quote, which is, "We are now dumber for having listened to what you just said."
Yeah.
I now feel dumber for having gone down this and doesn't anyone else feel like it's like, why was it was a waste of time all around? It was a waste of time for him to file it. I'm just angry. I don't know why I'm angry.
And Laura Owens' prime defense in the criminal case is blame David Gingras, because he did some really poor choices. Really poor. Included but not limited to, with more or less baseball signs telling her how to testify on the stand.
Oh, I do remember that part. Yeah. I remember that part.
Yeah. But will she do it? Will she turn against the one lawyer about... She has had more lawyers than Sarah Boone.
No, I don't think so.
I actually believe that David Gingras is lawyer number 9.
I can't buy that. I don't. Lawyer 9? That sounds...
The Clayton Eckert case, I think she went through 7 attorneys. I'm not entirely sure.
7.
Yeah. And then all of a sudden here comes Mr. Gingras, and all of a sudden he... I mean, if I were Laura Owens with a sound mind, I would blame David Gingras completely.
If you were Laura Owens, you could not have a sound mind. Those two things do not live in the same sentence.
No, but the mind can hear sounds. Is that what that means? Her mind processes sound? No, I don't know. That's...
Yeah. I mean, but that's basically her only defense in the criminal case. Bad lawyer advice.
I don't know if that's going to help her too much. I really don't.
I don't know, but just because it's her only defense doesn't mean it's a good one.
Not necessarily. I don't think it helps her. I think she's fucked. So, anyways.
Yeah.
Well, that's something. I didn't realize that was going to be as interesting as it was. There, look, I haven't had you on in over a year. You yelled. I listened. I answered.
Yeah. I'll see you in a year.
Maybe thanks, because there's a new Gingras filing calling anyone covering this case part of a cult. So, hello, fellow cultists. Yep, we read that. We did. We saw it with our own eyes.
I might be in Canton, Massachusetts in a rubber duck suit, by the way.
Why would you do that? Why would you do rubber duck suit? Why would you do Canton, Massachusetts at all?
Because it'll be funny.
Funny. You do know that one of the investigators in the Karen Reed case for 90 days investigated the witness intimidation through rubber ducks that somebody placed out with messages of "This is the real killer." So
rubber ducks are now a real thing.
Rubber ducks. And he spent 90 days plus 20 hours overtime, went in front of the judge and said, "This is tampering with witnesses." And the judge basically told him to fuck off. And since then, it has been very funny for people to show up in Canton, Massachusetts with rubber ducks. By the way, in September of next year, I will be in and around Boston, Massachusetts.
Okay.
Let's see how they will deal with a 6'4", 300-pound rubber ducky.
6'4". Why are you 300? That's you're 300 pounds?
Yeah, I kind of
6'4"?
gained.
You're-
I kind of gained some weight.
No,
What
I
have
was
you
gonna
been
say
eating?
you
Lead
hold it
pe-
about as well as any human being I've ever. I'm looking at you like, what are you built out of iron?
Okay, there it is.
That's a big rubber duck, bro. I want to see that rubber duck. I want to see that
And I
rubber
mean,
duck.
at 6, almost 6'4", I mean, let's just say I'm between 275 and 285 normally, depending
Yeah.
on which end of the buffet I am. And
I'm with you. I get it.
yeah,
Tell
I'm-
you what,
my problem is I have arthritis in both knees and one ankle. I wish I could run and bicycle more, but so what used to be more prominent up here is now in around my waist.
I can sympathize, my friend. I absolutely can sympathize.
Hmm.
So, let's
So I
see.
have
I've had to change my diet a bit to try to keep that under control.
Yep, I'm with you.
Hey, what can you do? What can you, well, of course I could eat more vegetables and not drink beer, but what's the
Vegetables?
fun in that?
What are vegetables? I don't understand.
French fries.
That's what it is. My theory on vegetables is the animal that I'm eating got there first. So it's called proxy consumption. I don't know that it's picked up anywhere else. I just know that it works for me. It might not work for everyone else in the world, but I figure if the animal ate the healthy thing and I eat the animal, then I'm happy. And well, I'm happy. I don't know if I'm healthy, but I'll be happy being happy.
Yeah, but my doctor is so mad at me because after every one of these slightly bust Friday law show I do, the week after I get myself tested because I'm not getting younger, and I kind of can drink like a fucking sponge. The week after one of my drinking binges, I go to my doctor and she gets mad at me because why are you healthy? My cholesterol is okay, my sugar levels are okay, my liver is okay, so I'm fat and healthy.
She's
And
hoping you die.
She's so mad at me. I mean,
she bought an insurance
why are
policy
you doing
against
this?
you.
That's pretty wild. It's pretty wild.
Yeah.
Let's see.
But yeah, I told you about the Laura Owens case. Thank you for hanging on. Tomorrow I will do more reading about the Delphi case, which is a completely type of clusterfuck. The Delphi case is sad.
You know, Nick, you gotta less sad, my friend. Fewer sad cases. Although if they're not sad cases, I guess it's kind of questions
because
to
Rick
cover them.
Allen is rotting away in prison for 130
Oh, that's
years.
that case.
For something
Judge
he
Gull.
did not do with Judge. Now the appeal is on the way, and they have talked about. Okay, this is what we are going to focus on.
Yep.
And that's the thing. This case has so much crap in it. They have to focus on something. But tomorrow I'm going to read tomorrow your time. I'm going to read about the Frank's motion. The one they asked for 3 days. They got less than 1 day to argue the Frank's motion.
That's pretty
about
wild.
third party culprit. and they were denied the third-party culprit, even though 2 people actually confessed long before Richard Allen was even a suspect.
Pretty freaking.
Yeah, it's infuriating. It's one of these cases. It takes a toll on you because you read it, you see it, and you can't do anything about it, except hoping that the appeals court will see it. But then again, if they say, "Hey, fucked up trial, send it back," and it's still Judge Gull.
Well, Niklas, if this thing is actually 132 pages, you reading
The
it's gonna
Frank's
be quite
motion is
the-
132. This is a hearing about the Frank's
Oh,
motion.
okay.
Yeah.
Okay. Then don't read the 132 pages on screen.
No. No. I already
Ridiculous.
read it.
That's a lot, man. I don't know that I would ever put something 132 pages together and put it in front of a judge, but let me get caught up on some of these, and then I have to actually get to the stories that we said we're going to talk about this evening. So let's see. Jackie Lynn, we're not a cult, we're a disorderly mob. Please learn your groups of chaos gremlins. Yes, very, very accurate. Katie Hewling is saying cult membership dues. We are now. It's going to just absolutely be a cult. Then Froggy Girl, I have a Cthulhu shirt that says it's not a cult, it's a team building. That should not be the official cult shirt. That's bad juju. Torin 3, my weekend will be fabulous. I get to have Andrea Burkhardt as a guest. Glad you're all doing well.
Nice.
That's awesome.
Torin, nice.
Say hi to Andrea. That's phenomenal. Finally freed. Runkle's hair isn't pretty. As has been said, it's dapper AF. I am inclined to agree. It is dapper. So is Nick's. Fluffy Buddy, happy FNF. Hope you all have a great weekend. Thank you. Mildred, Katie, have you heard of Lawrence Krauss in Albany? In a TV interview last month, he admitted to killing his parents over a decade ago, then committing social security fraud. I have not.
I've heard of it, and I'll be following up on it when I can.
Oh, there you go. So follow Ian to follow that case. Isaiah to the lumber lawyer. Oh, thank you, Isaiah. Very much appreciated. Katie Hewling, thank you for gifting 50 memberships. Very kind of you. Absolutely amazing. Cootie Patootie Tootie. Happy to see you all streaming. Hey, Runkle. Waving. Chris Cat Queen. The military curse you way of saying crazy clusterfuck is a Charlie Foxtrot. If you ever want to use that. Every now and then I just don't mind saying it verbally. Just because why not? Mostly harmless fuzzball. Lauren has admitted it's her account.
Oh,
she uses the avatar described in the motion for the same reason Ian uses AI images of Janet.
Okay, I didn't know that.
Okay. Victor Man 7777. You should see Gingras' initial filing in Arizona where he spent a number of pages ranting about Trump. I recall that.
Yeah,
I remember that a little bit. Kelly Cal, I'm a 3L on journal. Where's your blue book or state citation guide, sir? Yeah, you don't cite law.cornell.edu. That's just a general rule of everything. Jackie Lynn, can we hear the Cali judge's rejection of Gingras' motion? I'm up to hear a lawyer gets panked. Just let me pop some popcorn. I don't think we do.
It was simply motion denied.
Yeah, I imagine see you later. K-Rab, David has a reputation for not playing well with others, which is why he has a solo practice. I can imagine that would be a complicated personality to be around.
That's a gentle way of putting it.
Yeah, exactly. Jackie Lynn, Ian, I sent you what I could find from Arizona Superior Court regarding the Laura Owens criminal case. So you've got that in your email.
Check that out when I can.
Hey, Rab, if you include all the lawyers going back to her original DVRO with Mike, Gingras is her 13th lawyer. Youch.
Oh.
That's tough. Ouch. Jill Higgins, oh my God, I want to see Nick in a rubber duck suit in Boston. Be the best sight here in a long time. I don't know that I will ever I don't think I'll ever be able to just visualize this. So I'm agreeing with you that we probably have to see it.
If anybody knows where to order a 4XXL rubber ducky suit, let me know.
I just didn't want to. I don't even want to think about the types of websites that you would be on where you're typing in the phrase 4XL rubber ducky suit.
And I just
Rubber
feel
duck
like it's a
fursuit, and you'll
a
find
corner
something.
of the internet that I don't know that I want to be on.
I mean, you can find a suit. It'll just be expensive and have like
Yeah.
convenient holes.
that,
So
nope. It's convenient for a purpose that I don't want. Nope. And I don't want to. I like the corner of the internet that I have, which is like just like not involving giant rubber ducky suits, and we're gonna leave it right there. I like that. So, grilled cheese. I'm thankful for the confidence I've gained from the LawTube community. Hopefully, I will be accepted into law school soon. I'm sure you will,
Hey!
grilled cheese. I'm sure you will. AG, happy FNF, working hard to certify every week. Also, been home fermenting, especially Chinese pickled veggies. Making stuff makes me feel better. That sounds delicious. So cheers to you. There's a couple more. I'll pick those up in a little bit later. Carolyn Knight, I saw this. Any recommendations for a free speech attorney in Virginia? Go ahead and email me. Oh, those look good. Go ahead and email me, lawandlumber@gmail.com. I'll take a look at that and see if I can't find someone to refer you to. There's not a lot of them. They're pretty rare. So let's see. Or they're not, it's not that they're rare, they're expensive. That's the challenge. And the ones that are not expensive.
By the way, your warheads. Yeah, I bought them when I was in the States. It's kind of lame.
Okay. You eat pickled fish. I don't want don't call my warheads lame. You eat gross stuff too. You eat gross stuff.
And for the record, Jeff only got 5 bottles of booze out of the United States. I got 8.
I heard you snuck them out. What is that?
This is something I gotta.
Haggis? Oh my God, no. Haggis and tequila. You're one of you's holding up haggis, the other one's holding up tequila. That sounds like the worst combination I could ever think of. Nope, you're adding whiskey to it. It makes it worse. Oh, that's good. Yep. Love it. Absolutely love it. And Chin. Look at you.
Temple of the Moon, Jim.
You are you're now a smuggler.
Seen you.
Yeah, look at you smuggling booze. You bootlegger.
And
okay.
The funniest. This is from Utah.
No, it's not.
It's from Utah.
That's
5 wives with vodka.
That someone had some fun. That's terrible. Okay, hang on. I'm gonna swoop. Wait. Yep, we saw the bourbon. All right, I got to swoop. New topic. Okay, so the new topic, we have 3 possible we're going to do. Let's do the
It's 5 a.m. my time. I'm going to fuck off.
Well, sleep. Don't do just sleep. Do that.
I mean, he can do the other if he wants.
You can if you want. I would never say that to you.
Yeah.
Go get some sleep. All right, buddy. Thanks for jumping on. Thanks for giving us the debrief. Have fun tomorrow.
Thank you. Have a good time. And I will see you hopefully in less than a year this time.
Yeah, less than a year. I'm terrible.
Have a good one.
Time.
Subscribe, you know, all the things. And yeah, see you. Bye-bye.
See you, Nick. So Nik Starow, please go check his channel out. Fun guy, really nice guy. Probably one of the most positive attitudes that are out there. Not boring and downtrodden like me. And anyways,
yeah, you can say it.
What? I'm always sad, depressing, and boring.
Oh, we are.
I don't know if we are. Isn't that a song? Like a song.
We are sad, depressing, and boring. I don't think that is a song.
It might be. Could be. You never know. Let's see. I was gonna actually pull this story up. So I wanted to close the loop on the Brian Walshe case real quick first, because Brian Walshe we were gonna start covering, and we were gonna actually, be in court listening to stuff. And all of a sudden, we're not, because now we have a competency evaluation that is being conducted
which at this stage, it was pretty wild to see that actually happened. So let's see. Share screen. Ryan Walshe undergoing competency evaluation after jail stabbing. What we know looks like since his arrest in January, he's been model inmate at Norfolk County Jail. His lawyer said this week the now 50-year-old Walshe being held without bail on murder charges filed in connection with the death from his wife. This held a job at the jail and maintained friendly rapport with the jail staff and fellow inmates. Okay. Is that all that article has about that? Hang on. Courtroom audio answering questions from the judge. Go away. During impromptu hearing this week, you can hear him. Okay. But why is he's getting an evaluation? Why can't he? Do you understand that your attorneys have expressed to me in their pleadings and affidavits, we call them, that they have concern about your ability to participate in your defense in this case? Yes. And you understand they have so informed me of their concerns based on what I read in those affidavits. As a preliminary step under the rules that govern these things, the rules require me to determine whether you have any doubts whether you're competent to stand trial. So I have to do an evaluation. If the court finds there is doubt as to whether you're not, or if you can assist in your defense, then you can order exam. And I did that this morning. I'm sorry, can you repeat that? You said order something. I can order an examination of you. That process was something I thought was appropriate. So I asked the doctor to come to assess. We call preliminary assessment of whether or not we should do anything further. That's what happened this morning. You understand that? I believe I'm clear on that. Yes. All right. Do you have any questions for me? Not at this time. Thank you. Interesting. Okay. So that's been continued out. So we don't have a new trial date. And that is where that case stands. So Walshe does not begin. Kouri Richins' trial is set to begin in February. And that's why we were talking about that and why Walshe is not going forward right now. So that's the brief TLDR on that. And let me see. Queue up where I had to go next. Swoop. I accidentally pulled up a lot of articles on the stupid competency evaluation, closing 9 million tabs of things that I had pulled up and I don't need.
You need all of them.
I need all the tabs. Every tab.
Mm-hmm.
That makes perfect sense. You know what? Let's talk about the Hatchet-Wielding Hitchhiker case. And let's see if we can't find. I actually think that isn't his interview actually out there on YouTube? I imagine it is. Let's see if we can't find that real quick. Hatchet-Wielding Hitchhiker. When I type in Hatchet-Wielding Hitchhiker, it comes up with song. I don't want a song. I mean, the song wouldn't be terrible, I guess. Okay, so this dude, let me pull this up screen so you guys can see it, so it's not just me staring at it off into space. This dude.
Do you mind? What do you want to talk about?
What happened today?
Well, went straight out of Dogtown, skateboarding, surfing it up. Before I say anything else, I want to say no matter what you've done, you deserve respect. Even if you make mistakes, you're lovable. And it doesn't matter your look, skills, or age, or size, or anything. You're worthwhile. No one could ever take that away from you. Now, this stuff right here, I was driving and I was in the passenger side of this car, and he comes over on there. He was over by the recycling center. He says, "Oh, when I was in the Virgin Islands, 30 years old on a business trip, I saw this 14-year-old."
I completely forgot about this interview. This escaped my life for the longest time. And now I'm watching this again and remembering that this actually happened and this was real life. He was born in Edmonton.
Mm-hmm.
I didn't know that. Really? Okay.
I was like, you what? He's like, I raped this 14-year-old, starts crying, gives me a big hug. He's just like,
There goes monetization. Why'd you blurt everything else out? You blurted everything.
We're gonna blurp everything except the word that YouTube's gonna hate.
Come on.
300-pound guy. I'm like, oh, shit. You must be f***ed, man. Like, what's he talking about? I didn't take him seriously at first. Comes driving down this way. He's like, you know what? I come to realize I'm Jesus Christ, and I can do anything I f***ing want to. And watch this. Bam! And he smashed into this f***ing guy right there. Pinned him in between that f***ing truck. And so I hop out. I look over, the guy's pinned there. I mean, like, freight train riders know this. Like, if you get pinned between something, do not f***ing move that shit.
Whoa. Like, just... This,
Otherwise you bleed out. Like,
It's
motherfucker, I ran in, I grabbed the keys, he's sitting there like nothing even happened. And like, man, if you started driving that car around again, man, there would have been a hell of a lot of bodies around here. I hop on out, and so I grabbed the bag, I threw it over by that pole right there, and then buddy gets out, and these two women are trying to help him. He runs up and he grabs one of them, man. Like, a guy that big can snap a woman's neck like a pencil stick. So I ran up behind him with a hatchet, smash, smash, smash. Yeah.
The lady said you saved her life.
wow. So just imagine being that reporter. You're that reporter. What is his facial expression right now? Just going, because do you think this is the first time this reporter has heard this narrative, or is this like the third?
It doesn't much matter.
Smash. That's a lot.
She was the one who got grabbed by that fucker. You know what? F is cool. That guy ain't. Shit.
How'd you get in his car?
I'm sorry. I'm not adult enough. What? I forgot this guy entirely. This went viral. Oh my God. Well, Kai, his name was Kai, I think. Let's see. Kai went to jail. So that recording, this interview occurred February of 2013. That was this interview. The video gets uploaded February 2nd, 2013. The video has over 8.4 million views. And then, oddly enough, would you be surprised that this same person was arrested on murder charges on May 16, 2013 for the death of a New Jersey attorney, Joseph Golfi?
I mean, he's living the dream.
Yeah. So he takes the stand in his own defense. Outburst during his defense lawyer's closing arguments, nearly leading to the expulsion from the courtroom. The jury found him guilty of murder, and he was sentenced to 57 years. 57 years. He has to serve 85% of that before parole is possible. Here, this one.
So he's got to live to be like what, 82 before he's eligible for parole?
Pretty much 73, something like that. So found guilty of beating 73-year-old man to death. This dude. So guilty of first degree murder, brutal, senseless crime. Sincerely thank the jury. He cast his client as a home-free lifestyle who always looks for the best in people. Really? Because the guy gave an entire interview about hitting someone with a hatchet.
I mean, he was looking for the best in people. And a hatchet was apparently the way to get it out.
Apparently.
You just gotta really dig for
The lawyer and McGilvery raise their voices and talked over each other. You don't say. The dude that's in the interview that's going off on millions of tangents and talking very loudly spoke over his lawyer. So then we've got the poured him a beer. He's 30 years old. So anyways, he gets sentenced to 57 years, has to serve a lot of it. During that time, this lovely individual, while he's in jail, some of our friends, rather people that I've become friendly with, have been covering that particular case. Some people on the YouTube's sphere who analyze behavior. And they covered the case, or they covered it, trying to... Oh, no, wait, did he actually sue the Rolling Stone too? Please tell me he did. I think he did. Let me see. Oh, this guy. He has filed a lot of lawsuits since being in prison.
good for him. A man needs a hobby.
It's not the hobby I would suggest that one would, you know, possibly go to try and obtain.
No,
District court judgment. No, I wouldn't do that. Well, yes, if you're really that bored.
I mean, it's
can't
not like there's a
imagine.
whole lot of other things to do there.
They don't really give you hatchets in prison.
Not even if you ask real nicely.
Okay, so here we go. Reply and response, withdrawal of motion. Motion to compel. Judgment. So, surprise, surprise.
I have
no.
I have a thing I have to go attend to, so
Okay,
I
go
will
have fun.
be back later, maybe, and maybe not. We'll see.
Go have fun.
Oh, yeah. See you.
See you, bud. All right, so hatchet-wielding crazy person filed a complaint. I'm trying to get to it because Pacer went and did a fucking update. Pacer now requires two-factor authentication, which drives me nuts. But we can go through this. In the Middle District Court for the Middle District of Georgia, U.S. District Court, Middle Macon Division, we have this. Caleb. Do we just call him Kai? Is that going to be the easiest way to do it? I think we just call him Kai. So Hitchhiker Kai files a lawsuit against Greg Hartley, Chase Hughes, Body Language Tactics, Scott Rowson, Idea Bang LLC. So basically the behavior panel. Because the behavior panel did a video that he didn't like. So the defendants filed a motion for judgment on the pleadings, asking the court to please dismiss, give us judgment in our favor on this defamation case that was filed by Kai the Hitchhiker. So the plaintiff filed the lawsuit alleging the defendants infringed his copyright and trademark rights. That's pretty wild. that he said that by using his name, image, voice, likeness, and marks Kai the Hitchhiker, Hatchet-Wielding Hitchhiker, the Hatchet-Wielding Hitchhiker, and Smash, and defamed his character. Did he actually trademark that? That's pretty interesting. Having considered the pleadings, the parties' arguments, and relevant legal authority, the defense motion for judgment of the pleadings is granted. Because the plaintiff can allege no other facts to state a claim that is viable, any amended complaint would be futile, and thus the plaintiff's amended complaint is hereby dismissed without leave to amend. So here's what we have. Pro se individual filing. The pro se individual, being Kai, is currently serving 57-year sentence for first-degree murder. February 2013, he rose to internet fame as the hatchet-wielding hitchhiker after he gave interviews to a local Fresno, California news reporter in which he described smash, and smashing Jet Simmons McBride 3 times over the head with a hatchet after McBride crashed his car into a group of pedestrians and attacked bystanders at the scene. Fresno authorities concluded that the plaintiff used justifiable force in protection of the bystanders and cleared him of any wrongdoing. You know, hitting him with a hatchet was justifiable to protect the third parties. Hitting the other dude in New Jersey, not the case at all. 3 months later, after gaining media notoriety, including an interview on Jimmy Kimmel Live, seriously? Really? And why not? Why not? He was arrested and ultimately convicted for murdering Joseph Golfi, a New Jersey attorney. Just wild. Plaintiff's arrest was unrelated to the hatchet incident. Imagine that. Imagine just that sentence. The arrest for murder was unrelated to the hatchet incident. Sure. On January 10th, 2023, Netflix released a documentary about Kai. That is a, let's call that a boring footnote. Hatchet-wielding hitchhiker that described his background, interviewed those around him during his rise to fame, and detailed his subsequent murder conviction. 5 days before the documentary was released on January 5th, 2023, the defendants created and published an episode of on their YouTube channel, The Behavior Panel, wherein they analyzed the clip and made statements about plaintiff based on their assessment of his body language and behavior. The suit arises out of comments made in that YouTube video. The day of the hatchet incident, plaintiff, who describes himself as a homeless professional street performer, was hiking around Bakersfield, California when Jet Simmons McBride picked him up. The two drove to Fresno, picked up a bag of marijuana, and shared a joint at a nearby recycling center. As they were driving away, McBride made a comment to plaintiff about how he previously confessed to, a 14-year-old. Eventually, with both hands on the steering wheel, McBride intentionally crashed his car into a crowd of power line workers, hitting one of the workers with the car. McBride got out of the car, grabbed the bystander, and a bear hug escalated force against her. Plaintiff exited. The bad guy was saying, "I'll kill you." Or the bad guy, who knows who the bad guy is at that point in time. Then he used his camping hatchet to strike McBride 3 times with the force of McBride's head in defense of the bystander. Law enforcement came to the scene, determined the plaintiff used justified force in defense of others, was cleared of any wrongdoing. The incident was released without any charges or reprimands. That same day, he gave an interview. He said, smashed McBride's head. He admits he became widely known and recognized as Hatchet Hitchhiker because of his heroic acts and made other public appearances, including on Jimmy Kimmel Live. Indeed, plaintiff admits he is famous and widely recognized for his name, voice, likeness, and unregistered marks: Kai the Hitchhiker, Kai the Hatchet Hitchhiker, and the Hatchet-Wielding Hitchhiker, and smash. Oh, so you might say that you're a public figure. Okay, sure. For his distinguishing devices of hairstyle, garb, performance, and body appearance in the interview. No, you don't say. That demeanor might be a little bit distinct.
She was the one who got grabbed by that fucker. You know what? Is cool. That guy ain't shit.
How'd you
Okay. So after these events, he was convicted of homicide in connection with another unrelated incident in New Jersey, which he states was in response to having been drugged and sexually assaulted. He's currently serving a 57-year prison sentence in New Jersey as a result of the conviction. He alleges that the behavior panel, Scott, Greg Hartley, and Chase Hughes, are employed by and or officers of Idea Bank LLC and bodylanguagetactics.com. Defendants maintain the YouTube channel The Behavior Panel, where they analyze body language and human behavior in videos of public interest and hold themselves out as the world's top body language and behavioral analysis experts. Oh. Oddly enough, Spidey, one of their best friends, I would put in that camp as well. Defendant Scott Rouse is a body language and expert analyst. Is that from the complaint? Who trains law enforcement in the military interrogation of body language and created the #1 online body language course at bodylanguage.com. Greg Hartley is a former Army interrogator, interrogation instructor, resistance to interrogation instructor, and has written 10 books on body language and behavior. And Chase Hughes has 20 years in the U.S. military and published the #1 best-selling book on behavioral profiling, influence, and persuasion. January 5th, the individual defendants published a video on their YouTube channel wherein they analyzed the clip and made statements about plaintiff based on their assessment of his body language and behavior. To view the YouTube video, users had to click on an image of plaintiff's face with the words hatchet hiking body language. Okay. Advertised YouTube on video on YouTube, Google, Bing.com, MSN.com, Yahoo.com, and a host of other search engines. I don't know that they're the ones that put it out there. Maybe they did, maybe not. Plaintiff filed suit against defendants to bring claims of trademark infringement, copyright infringement, racketeering, wow, and defamation from the creation of the video. The copyright protect spoken words were. This is so the plaintiff claims on February 1st, 2013, he created the copyright protected spoken words smash, smash, some mash, and dramatic work, smash, smash, some mash, and performed those works in the KMPH clip. Plaintiff alleges defendants violated his copyrights and used plaintiff's name, voice, likeness, and marks to falsely endorse their products and services in the same video. They slandered him. That is something else. So legal standard. Do we really need, it's basically just taking everything they're saying is true. Discussion. Plaintiff cannot maintain his Georgia state law defamation claim as a matter of law because defendants' allegedly defamatory statements are, surprise, surprise, opinions, subjective assessments of the plaintiff, and rhetorical hyperbole for which they cannot be held liable. Really? We had a whole lawsuit where you're doing behavioral analysis and you advertise it as behavioral analysis. And you have the temerity to call it opinion. Of course it's opinion. Easiest answer in the world. Plaintiff alleges the defendant made 28 slanderous and libelous statements with reckless disregard for and or knowing knowledge of their falsity with actual malice intending to harm that would result therefrom. Defendants' allegedly defamatory statements include telling viewers they will analyze the body language and behavior from the news clip and determine whether he is a sociopath or psychopath. Commenting on plaintiff's odd behavior for someone who's killed someone in the last 3 hours. Questioning whether plaintiff has a personality disorder and lacks language and relationship skills. Questioning the relationship between the plaintiff and McBride. Driver of the car, be it a drug deal, be it a prostitution situation, whatever has happened there. Commenting that the plaintiff was trying to be a hero, calling plaintiff a drifter and a vigilante. Suggesting because he stated in the news clip he was from Dogtown. Plaintiff was kind of suggesting that he's a mutt out of the back streets
bit of a mongrel from the back streets. All of these statements are opinions, every single one. So, under Georgia law, it has 4 elements for defamation: false defamatory statements, unprivileged communication, negligence, special harm. We really need to go into all this. This dude, this same person said, you slandered me for calling me. What did they say? It was to wonder whether or not he's a sociopath, a psychopath, whether he was a kind of a drifter, vigilante, a mutt out of the back. No, we're getting all of that. I can't imagine that this person would be called that.
Get in his car. How did you?
I was hitchhiking. Good thing I was hitchhiking. Yeah, people say don't hitchhike. Well, this is what happens. At least I was here.
So he did this on purpose.
Dude, that guy was fucking cooked out, man. Like, he's beyond Howley. Like, I don't even see any breath in him. You know what I'm saying?
Can I get your name and where you're from, if you don't mind?
I'm Kai.
Kai, can I get spelling for you?
Straight out of Dogtown. Kai.
K-A-I. Do you have a last name?
No, bro. I don't have anything.
Okay. So this is a good question. Wait, but is his understanding of defamation better or worse than Janet's understanding of it? I don't know. Might be, could be. Then there's trademark infringement. So sure, we're going to call those trademarks, but they're not. So you can't prove that there's any confusion. How am I going to say that there's a smash is a trademarkable phrase? I don't know that I can do that. This went on. This is again. So apparently the theme for this evening is a lot of unneeded ink on paper. Just a lot. Because lawsuits get filed that don't necessarily need to be filed. Copyright infringement claims, those get dismissed. This was good practice for the judge's law clerk, though. So the clerk actually, there's a RICO claim, federal RICO claim. Oof. Let's see. Federal RICO claim makes it illegal for Federal RICO Act makes it illegal for any person employed or by or associated with an enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering. So racketeering. How is this racketeering? Okay. So we're just grabbing statutes and writing them and then saying this person did the statute. Oh, this sentence is wonderful. Specifically, he alleges the defendants Idea, Bang, LLC, and BodyLanguage.com employ the individual defendants and are RICO enterprises, quote, engaged in activities which affect interstate or foreign commerce, end quote, and act in concert, quote, through a RICO pattern of activity to commit willful copyright infringements, fraudulently entering click-wrap agreements so as to upload infringing content and thereby defraud money from bidders on advertisements. Okay. So there's engaged in activities which affect interstate foreign commerce. All right, we just put it in a pattern of RICO pattern activity through pattern of RICO activity to commit willful copyright infringement. So that's the fraud he's saying. Fraudulently enter click wrap agreements. Where? So as to upload infringing content and thereby defraud money from bidders on advertisements. What? That doesn't make any sense. I can't even process the logic of what he's trying to say. So how does that work? Okay, why not? That doesn't make any sense at all. So trying to say that he's trying to say he suffered an actual injury, no injury. So all of this, 29 pages to dismiss a claim that I don't know ever should have been brought in the first place. It's not bad. Not bad at all. It's a lot of pleadings. And that case went on for a while. Here, I'll show the docket. So let's see, there's the docket. It was filed 2024. It's a lot of paper. It's a lot of just all over the place. District court, transfer, order on motion for extension of time. There's the arguments over discovery. Like, miss me with this stuff. I don't want to have to defend stupid defamation because of a body language case that I did or did not want to cover. What a mess. And then he's got a case against Rolling Stone, apparently. The hell? All right, criminal defense lawyers. If you are in the chat, can you tell me what the hell this is? Caleb McGilvery versus a case number. Is that a thing? Does that happen? Because I don't think I've ever heard of that. I don't understand how that works. Because that doesn't make any sense. You know, prisoners be having hobbies. So there's this one too. So he filed an appeal in this case. This was a case. Notice of appeal. So Caleb McGilvery versus Rolling Stone. Looks like he appealed that to the Second Circuit Court of Appeals. Pro se. They lists his detention location, P.O. Box. There we go. So we got prisoner number where he's listed. Makes a declaration for the appeal. There's the mailing. And there's the docket sheet. This is what he filed the lawsuit against Rolling Stone, against Winter Media, Orlo Stern, complaint against Rolling Stone. That. Okay. This is the thing. This was a case. What's that case number? What the hell? I almost want to read the case. What the hell is the case number? McGilvery versus Rolling Stone, huh? Rolling Stone. Where is the case? There it is. What was the complaint against Rolling Stone? List of defendants. Introduction. Oh, this is great. It's like a Gingras motion. This is phenomenal. The Rolling Stone is no stranger to this court.
You know what's funny? So we can we play a game? What's the game? We're gonna play the game. Who wrote it? David Gingras or Kai the hatch-wielding hitchhiker? Do we? This is. I think this is probably a good game to play. As one of the most well-known publications in America, they become somewhat of a cultural icon. Who wrote it? Kai or David? In recent years, however, their print-based magazine has lost more and more revenues. Market trends seem to indicate that people are now interested in streaming services than in print-based magazines, yet Rolling Stone still has a kind of clout that gets the world's largest streaming service to allow its journalists to watch and write and review for a documentary film before the film is even released. Unfortunately, unlike the times in the past, the Rolling Stone is not in a position to question the narrative of the streaming giant. If Netflix says things are one way, the truth be damned, so says Rolling Stone. If Netflix publishes false attributions of criminality, the Rolling Stone doesn't bother to read the underlying case. They just go with it. Oh, yeah, I love it. Rolling Stone is the criminal arm of Netflix. Gone are the days where Rolling Stone would never sacrifice the truth to kowtow to an preach, Kai the hatchet-wielding hitchhiker, preach. Today, the court hears a case where the Rolling Stone, seemingly fearful that Netflix might withdraw their favor, has blindly followed the streaming Goliath into you even capitalized Goliath, good for you, into a battle with a modern David. Plaintiff has made his name by saving a crowd of people from a large homicidal maniac who attempted to kill them using his camping axe to thwart the would-be axe murderer or would-be mass murderer. This is great. Why is my mic messing up? What is happening? Stop making static noises, microphone. Hang on. You shouldn't be making static noises. I haven't done anything. That's weird. Hang on. Let me unplug and replug. We're going to do that. Don't break the button. Why is the mic glitching? It shouldn't be glitching. There's really nothing that should be. Y'all, if you can see the setup is there. The mic should not be glitching. Hopefully it's not screwing up anymore. Why is it going robotic? I hate this. I hate this, everything. Let me see. Give me 1 second. Stay peaceful. No one fight or yell. So we unplugged the mic. We plugged the mic back in. We see if that does anything at all. Maybe it does. Maybe it doesn't. Let's see. If I hit the setting button, maybe I can tweak the settings a little bit. People are now saying it sounds fine. I don't know what's going on. I don't know. I'm going to go with this is just, I'm just not going to touch it. All right. People say it's okay right now. I'm just going to leave it right where it was. Plaintiff was a homeless street performer who was hitchhiking at the time. He drank heavily afterwards to deal with his PTSD, which was triggered by the incident, in which he had to use what seemed like deadly force at the time to subdue the maniac. Many unscrupulous media types took advantage of plaintiff's drunkenness and easygoing nature, but when one unscrupulous lawyer drugged plaintiff's drink and assaulted him, plaintiff fought back. His conviction thereafter for homicide was in no way diminished his reputation for stopping the maniac, who wasn't admitted. That's for 10 years. And it's throwing journalistic integrity to the wind. I don't know what to do here. I don't know what to do, because here's the problem. Do I think Rolling Stone has thrown journalistic integrity to the wind? The fact that they've gotten sued multiple times and lost defamation cases, more recently in particular, I think that's probably true. So I agree with some of these things. I just don't think that you're the case. Enter defendants. Without checking the court transcripts, they quoted a Fresno cop contradicting his fellow officers who were actually at the scene to impute criminal conduct against plaintiff. Obvious to reason, they stated plaintiff laced a joint
as if it were a fact. Then in the next breath, parenthesizing, the toxicology results said otherwise. Most disturbingly, they falsely portrayed plaintiff as being at fault for his traumatic childhood. Calling him an arsonist prone to his fits of rage, they normally contact the subject of the article asking for information, providing opportunity to respond to such allegations. Okay. It's a standard journalistic practice which Rolling Stone used to follow back before Netflix said jump. Now they simply ask how high. Oh, that's cute. This is great. I don't know. Is this a Gingras filing or a Kai filing? Oh my gosh. Wow. Wow. So this is just a rant. That's what this is. We're going into paragraph after paragraph. 21 pages of this. 21 pages. Oh, count one. Defamation. Cool. Totally defamatory. I'm positive that they got that wrong. He was on Howard Stern too. I'm not surprised. Okay. Where's count two? Come on, Kai. Invasion of privacy. Invasion of privacy. Public disclosure of private fact, false light. Okay. On January 8, 2023, the Rolling Stone, a publication owned and operated by defendant Rolling Stone LLC, they wrote an article entitled Dark Tale, a hatchet-wielding hitchhiker went viral, then he killed somebody. They publish a false light portrayal of public discourse of private facts which constitute malice and is knowing their falsity or with reckless disregard for the truth. Oh, it's defamation. It's not invasion of privacy. Prone to fits of rage. No one describes me as being prone to fits of rage. Oh, that's what here. Plaintiff describes him as and in fact, he is known to those he is truly familiar with as self-disciplined and considerate, with compassion for those who are vulnerable and oppressed. Sure. You know what? I get it. I understand. I understand that the photo of this person is self-disciplined. Self-disciplined.
Where are you from originally? Are you from Fresno area?
Sophia, West Virginia.
No kidding. How old are you?
I can't call it.
Okay. What have you ever experienced anything like today? And what made you take the actions that you did?
That woman was in danger. He just finished what looked like at the time killing somebody.
Oh, well, you know what? I take it back. Maybe he is considerate. Okay, there we go. Count three, intentional infliction of emotional distress. Kai is emotionally distressed. Emotional distress. Oh gosh. Yeah. How are you emotionally distressed, Kai? Punitive damages. Please punish them for all of their misdeeds and terrible, terrible journalistic behaviors. Declaration that all of the acts described are unlawful and tortious. Oh, yes. Yes. $1 million in compensatory damages. Oh. That, you know what? The Rolling Stone article did $1 million of damage to his reputation. $1 million. Absolutely. You, sir, deserve the $1 million from Rolling Stone. We deserve the $1 million for having to read that entire thing. What a clusterfuck. Is there anything normal anymore? Did that just go away? Are we allowed to have normal things? Is that possible? I don't understand this.
Is the mic doing it again? Microphone. Making a popping sound every few seconds. I hate so much right now. So much. But Katie Hewling, Kai's emotional distress seems to be causing Rob emotional distress. No, my microphone is causing me emotional distress. My microphone is causing me emotional distress because it's causing everyone else auditory distress. And auditory distress for you means emotional distress for me. This microphone is a paid actor and is just fucking up my universe. Stop doing the thing. Be normal. Be normal. I don't know. I'm going to fix it at some point in time. I don't know how. There's a magical thing called time. I don't know what to do with it. I have a super emotional band-aid. Thank you, Katie. Oh, emotional damage. Emotional damage. Ian's mic problems are contagious, damn it. 100%. 100% contagious mic problems. Megan, aka Mega's autistic. I grew up in a cult. This one is way better. I agree. I like this cult. I didn't grow up in a microphone. I don't have anything plugged into anything. Let me see. Maybe. You know what? The actual input appears to be kind of glitchy. I don't want to shut it down. I don't know. Jackie, Lind, Rob, what's AI? What's all this distress? What about dat stress? And is this a cute dress? I like that rabbit hole. That's a fun rabbit hole, Jackie. Yeah, it sounds like a loose wire or interference. Well, let me do this. When I find something, let me see. Is there something I can play? There's something I can play, right? Did Kouri Richins' last bond hearing get heard? Because what I'm going to do is unplug the stupid microphone, plug it back in, which is going to take me out of commission while the thing is rebooting. Bail, indictment, exculpatory evidence, charges. Give me 1 second. Filters. Because why would microphones work? There was a little thing that I had. Let's do this. I'm going to do the Southern Febreze clip. That buys me, I think, a minute and a half. And we will try to do that. All right. So for those of you who have not seen this clip, enjoy. We're going to unplug, replug, and I'll be right back.
Mary Murphy, member for 9 months, so they can't believe. Okay, stop. I need the Southern Febreze. Hey, can somebody bring me the Raid? There's a bug. There's a bug in my studio.
What in the world is that? Oh my gosh.
And I don't want to turn the camera on it because I'd have to zoom out so it would all fit in the camera lens. It just went behind the cabinet. You guys, oh my goodness.
There was this bug that had a huge, I think it's a roach, that had a huge thing of dust on it.
I will tell you what's going to happen. What's going to happen is this. That bug, and when I talk about bug, I'm talking, it's those, they call them water bugs here in the South. We know what they are, and they're not water bugs. That was like, it was the size of a small dog.
It looked like a monster coming towards me. Holy cow.
Unmute.
And occasionally when we get one of these that come inside from outside, usually when the fall down, they're around the leaves outside. But when I get into the house, I have words to say, and now it's literally crawling towards my green screen. So I'm going to be on camera like this, and then on the green screen, you're going to see a bug crawl across the wall.
I can.
This is bad, guys. It's going to be a bad day. I can't step on it because it was like at waist level on the wall, and my feet don't go that high.
There's a series of questions.
Oh, I just put my arm
based
in
on
the
what
guts.
I heard Mr. Shapiro comment on about the 20.
Bug will be dead by the end of this show for sure. Bug has nowhere else to go. I mean, it's not like there are wires it can hide behind in here. Yes, cats will eat them. We're keeping the cat.
Okay. Hopefully we're trying that. Hopefully the microphone works. I unplugged it, replugged it. We did everything else. Those of you who hadn't seen that, you're welcome. You're welcome. That was fun. And it happened, I think, the same week too. It was during the here in my trial. So y'all have to tune in and let me know if the microphone issues are fixed. If not, then we live with what we live with, right? So let's do this. Let's catch up on the Kouri Richins case. People are now terrified from the bugs. Nik Starow, there might be cursing on my channel. 1/3 of my streams are demonetized. Oh my. That's not good. That's not good, Nick. Music to my soul. The fact there's been commentary recently on y'all's stream about how many tabs you both have open is just more affirmation that I belong here. Oh, you don't have to be shy about the volume. Not volume. I was reading another comment. Let's do this. We'll bring that closer. We're just going to stand really close to the mic. Light Queen, working on half-size dollhouse miniature while listening, finding out all the tools I don't have for this. Oh, so many tools. I built one dollhouse. It took me forever. Such a pain in the ass. That was before I had a CNC. I would totally CNC that. Apocalypse DOA, celebrating my main tumor shrank 20% after 1 year. Congratulations. That's remarkable. That is remarkable. Keep up the fight. Light Queen, Amazon for the ducky suit. 4XL duck suit. Bell, thank you for gifting membership. Sandy, such a wonderful community. I love being here. We love having you here, Sandy. Mo's been a member for 38 months. Golden Productions is a new member. Thank you, Golden Productions. Kayvon, can't believe it's been 33 months. Thanks for being here for 33 months. E. Warner, 3 years, 36 months. A lot of y'all, 36 months. Cindy Collins, thank you for gifting memberships this evening. Finally freed, unpacking from an unexpected move. So glad to spend my Friday with the FNF community. Hopefully the move is to a better place and that you are doing happy and well. Carolyn English, meh, time is a construct, better late than never. Thank you, Carolyn. I agree. Morgan, almost 3 years, 35 months. Happy to have you here for that time. Pop Princess, hope, hey Rob, hope all is well. All is okay. Microphone issues are the only thing that is becoming a problem right now. That's the only thing that's driving me nuts. But we can live with that. I think we can live with that. Ish. We can live with that ish. Let's see. Catching up. All right. Let's Swoop talked about the Kouri Richins stuff real quick. So Kouri Richins has some updates in the case. We'll go to Court TV for some reporting on that initially. Now that assumes that. What a messy way to read it. No, I don't want to do that. Do you have a print view? You have to have a print view. Don't be annoying. Please don't be annoying. You know, Rob, this would work better if you pulled this stuff up beforehand. It would work great if you had time to do that. That'd be awesome. Because then, you know, we can do that. Okay, so we'll just have to watch it this way. So, Park City, Utah.
author of children's book of grief counseling, accused. Hang on. So Kouri Richins is presently facing charges for murdering her spouse. Vodka gimlet, poison with fentanyl. Spouse has passed. She then writes a children's book about losing their father. Also tried to get money out of the estate. Lots of cases. But most notably is the murder charge and the financial fraud charge. So, charged with murdering her husband, Eric Richins, who investigators say was poisoned with lethal dose of fentanyl in a Moscow Mule. Not Gimlet, Moscow Mule. In 2022, the murder is part of a larger plot to get rid of husband and cash in on life insurance policy. Kouri's been behind bars the last 28 months after having been denied bail twice. Now her attorneys have filed a renewed request for bail, citing a failure by the prosecutors to turn over exculpatory evidence as a key change in circumstances that could qualify for her release. So the allegation is that Kouri Richins purchased fentanyl from her housekeeper. Okay. From Lauber. While Lauber initially told officers she never bought any fentanyl, she eventually told them that she bought it from this Robert Crozier. Crozier was interviewed several times, with the first conducted by police in May of 2023 when he was arrested on drug charges. At that point, officers say Crozier admitted to selling fentanyl twice in 2022 to the housekeeper. But an affidavit filed with the court as part of their motion, Kouri's defense said that Crozier has no memory of that interview because he was detoxing from drug use and was very out of it. Okay. When members of the county attorney's office went to interview Crozier in April of 2025, he told them he had never sold Lauber fentanyl, and rather than he had sold her OxyContin pills twice. Defense says the details of that interview were never disclosed to them. That part. This all turns on this allegation here. Whether the interview actually was disclosed or not. Defense claims the prosecutor violated the ethical duties by not disclosing the interview, which they said not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. Okay, now here's the thing. These two things are not the same. They just aren't. They're not. Did the prosecution withhold notes from an interview that could possibly be used in cross-examination of that particular witness to say, hey, isn't it true that you actually never sold that fentanyl to this individual from whom Kouri Richins purportedly bought it? Is it possible that, I don't know, hypothetically speaking, someone says something and then says something contrary to that within the same, time period or several years later or months later? All the time. Is it the be all end all? No. But is the fact that prosecutors might not have turned it over a really big problem? Yes. If that's true, if it was not turned over, that creates a very large problem. But I don't think that fact standing on its own does anything to eviscerate the case. Is it good fodder for cross? Oh, absolutely. That'll make cross-examination of this witness a lot of fun to watch. So they go on. This was not an oversight. This was continuing and knowing concealment. It's not a blemish on the fruit. It is a rot at the core, poisoning the whole harvest of justice. Oh my God. Really? We're going to use that level of hyperbole? It's a rot at the core, poisoning the whole harvest of justice. Really? That's so dumb. In addition to requesting the release on bail, denied, her attorneys have also asked the judge to order prosecutors to disclose all the evidence, including emails, texts related to the communication with Crozier within 3 days. Yeah, absolutely. 100%. Turn it over. You getting out on bail? Nope. Nope. Is prosecution going to be ordered to turn it over? Absolutely. Yes, 100%. Kouri's handyman, who was killed in a motorcycle crash in 2024, allegedly told investigators that Kouri also asked him if he could get fentanyl before the death. See, you don't really need Crozier, a drug dealer
who I don't know if we're really considering that person to be truthful inherently, that he sold drugs or didn't sell drugs. I can't get over this stupid line. This was a continuing and knowing concealment. It is not a blemish on the fruit. It is a rot at the core, poisoning the whole harvest of justice. That sound like ominous to anybody else? No, just me. That sounds the harvest of justice. When has justice been a harvest? Also, do we really have to, if we're talking about Kouri Richins, like, and how this absolutely goes to the heart of this case, and how could anyone possibly believe that Kouri Richins herself is guilty of anything that she's been alleged to have to have done? I can't possibly fathom. I can't possibly fathom. You know, that someone who might perchance write something like, I don't know, hypothetically, why can't I search? No, let me do that. I want to do full scene. Somebody might write this letter. Sky is saying even the gummies have fentanyl. And then the prosecutor will say, I tried to put the fentanyl in the gummies. The walk the dog letter that is absolutely going to be evidence at her trial. If you guys don't remember, we walked through this like at length, and this is quite problematic. I don't think that case turns on whether or not this individual said anything. Now, here's the bigger issue that I have. If the prosecution, we're having this is far too many cases where right now we're having prosecutors accused of, and in a lot of cases, being found to have withheld information. Murdoch, no, that was bullshit. But Norfolk County, in the Walshe case, Reed case, in other cases, that's a big example. Fulton County. Well, Fulton County is being in Fulton County. But I don't like the fact that this is happening all over the place. This was a different additional article. This one by News 4 affiliate, Utah. When Richins was arrested, she had been messaging a friend to obtain fentanyl. That friend purchased it through Crozier. Doesn't have any personal recollection of the detail. Tell me that he, how does that affect the case? It really doesn't. I also, the other thing about this one is the state, Utah, has not responded to this yet. They have not filed a written response. So I am very hesitant to say that this means what the defense is saying it means. That said, I did find this one interesting too. Let's see, told him certain. So the state interview, this was October 2nd was this article. Right? So the recanting happens, and then all of a sudden the state's filing amended charges again. They've amended it before. Park City, the Summit County Attorney's Office has again amended its criminal charges against Richins. She's no longer facing drug distribution charges. All right. So she's currently facing aggravated murder, attempted aggravated murder, and then 2 counts of insurance fraud, forgery, but previously she was facing additional charges, 2 counts of drug distribution and 2 counts of mortgage fraud. Okay. Updated charging documents come a week after the defense attorneys filed 2 motions asking for a judge to require them turn over exculpatory evidence. In their motion, defense attorneys say that she's accused of buying fentanyl from a housekeeper, but they can't make that causal link. See, that might be a basis for getting rid of the distribution charges. If one of your chief witnesses isn't proving to be reliable on how you got the fentanyl in your possession, then is it the wise thing to do to drop those charges before they go to trial? I would say so. I wouldn't bring it if I didn't have the goods to prove it. See y'all saying hey to Runkle in the chat. Are we saying, do we know what happened? Okay. Yep. Okay. So we're gonna throw some prayer hands up for a minute. I know that we've got some. Let me see if I've got a note from him. Okay. Yeah, that would be the basis for changing the charges. What I don't like though is that you've got these multiple amendments that are occurring. Yes, you're allowed to do that. It's not really a problem. Does the defense really think that this is what it's going to come down to? I don't think that's the case. Is it? So here's how the defense is arguing this. If the state cannot place fentanyl in the hands of Richins, the state has no case. Mr. Crozier's statement doesn't just poke holes in their case, it throws a grenade into the middle of it, leaving them nothing but speculation and conjecture, getting them nowhere near the realm of proving their case beyond a reasonable doubt. I don't know if that's the case. To date, the defense is only aware of one of these witnesses being granted any sort of immunity. The remaining witnesses face potential state and/or federal criminal liability if they take the witness stand at trial and testify consistently with their statements produced during discovery. The defense is asking for the witnesses to be appointed counsel to assert their fifth. Of course they want. Of course they do. Of course. The defense very much wants the witnesses to plead the fifth and not testify against their client. Solid move. What a move. Wow. Okay. Yep. Okay. All right. So these witnesses are going to be fun. At least you know we're going to get some activity out of this case. I think that's going to be the biggest part. So what does it mean? Not a whole lot. Fewer charges. That's what it means. It means that we have charges that remain. First of all, the notion that this is going to lead to her getting bail at this point in time, no, it's not going to. There's no chance. The charges we have are the murder, insurance fraud, mortgage fraud. Mortgage fraud's off the table. Insurance fraud and forgery. And realistically, what we have is the statement that was originally that he sold the fentanyl, and now he cannot recall. I don't know if this is proper reporting. Crozier now says in a sworn affidavit that he never sold fentanyl to Lauber. But that's not what I recall the reporting being. Let's see. And unfortunately, Utah puts every single one of these filings behind a damn paywall. And not a cheap paywall at that, by the way. So let's see. I think I tried to find at least one of them. don't know that I was able to. Where was it? No, I wasn't able to find the motion because the paywall was pretty significant. But the idea that Crozier, who originally says, I remember selling fentanyl from me to this person, doesn't necessarily negate anything. Because Lauber is still the one who says that she gave the fentanyl to Kouri. Just because we interrupted the chain of fentanyl, like where it came from, who exactly it was received from, I don't know that that's the be all end all. I think it's plenty of evidence that's sufficient to basically tell you what actually transpired. But do I like the prosecutors that are possibly withholding stuff? Not necessarily. I don't. Very much don't. And give me one moment, folks. I apologize. I'm kind of out of it right now. And the internet's just doing stupid internet shit. Because here, wait till that loads. Was loading. Oh, here we go. I like actually having the source documents and going through those as opposed to anything else, just because, reasons. And so we have the walk the dog letter. But walk the dog, but take vague notes so you remember. Private investigators doing research, what's the thing, blah, 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 blah. Also, this is absolutely upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football on Sunday, and Eric and Ronnie were chatting about Eric's Mexico trip, told Ronnie gets pain pills, fentanyl from Mexico, the workers from the ranch. Where was it? I wouldn't want to find them. Make sure they know this. Oh, there it was. Kouri has never done any type of pills, didn't like them. Rarely would she consume the only if Eric begged her because it was a special occasion. Reword this however he needs to make the point. Just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. It can be shortened to the point, but it has to be done upon information and belief. LOL, they never found pain pills or fentanyl in my house because he had it in allergy bottles in the work truck. And Cody emptied out the work truck within a week, so they were never found. When you talk to Ronnie about this, meet up with him in person. Tell him I need him to do this. Bring me home, and then we'll get those damn bitches. Like I said, I think that's just one part to the case, not necessarily the be all end all. We'll see. Hey, Phoenix. Thanks for being a member for 33 months. All right. And the last case that we had for the day, that's the Kouri Richins case. We'll see what's going to happen. I want to see the prosecution respond to that. I don't think we've seen one side of the motion, one side of the argument, which doesn't necessarily tell us much of anything at all. Really, it doesn't. Other than this is what is alleged to have occurred. The prosecution hasn't had a chance to respond yet. So I'm going to withhold judgment on whether or not there's anything there until we see something back from the prosecutor. Is it possible? Yep.
Is it a big problem? Absolutely. Is it going to result in dismissal? I don't think so, unless it's something that's going to. We'll see what they knew. We'll see how long they withheld it. For those of you who don't recall, we've seen one of these hearings more recently, I think in Fulton County. And judges tend to kind of bend over backwards, whether or not they should, in giving a lot of leeway to people that are, or to prosecutors who are withholding information. Kind of gives them time. So the last case that we were going to talk about this evening was the Mark Sanchez case. And we've got so for those of you who are not following, let's do this. Let me see if I can't find just a general article explaining what's happened here. Oh, wow. Oh, God. What a. I'm going to pull up an article that explains just the facts of the case, generally speaking. But then I'm going to pull an article up that is just media doing the dumb thing, which is not surprising because media does that. God, what a stupid. Sorry, give me one moment, guys. Well, I'm going to swoop. Give me a second. Just really dumb. Mm-hmm. All right. And that's. I don't know why that happened. That's really funny. Well, you got the intro again. Here we go. Double swoop. I've been streaming for 3 hours, guys. I'm to just give you an indication how the brain is functioning right now. It just isn't. We're operating on different brain power. Streaming is extra dynamic tonight. It absolutely is. Absolutely is. Mark Sanchez now facing charge of battery involving serious bodily injury. Okay, so what we have. No, go away. I don't want it. Oh, look, there's Mark Sanchez. You can see Mark Sanchez. There's Mark Sanchez. And there's him. We're going to watch that video in a second. NFL quarterback and current Fox Sports color commentator Mark Sanchez, who was arrested for multiple misdemeanors following a physical altercation this weekend, is now facing felony charges of battery involving serious bodily injury. The more serious charge was added after investigators learned of the severity of the victim's injuries. Yeah, they're pretty significant. This was a situation that did not need to occur. So the allegations involved 38-year-old man becoming involved in an altercation with a 69-year-old man who sustained significant and very serious injuries over a dispute about parking. Early Saturday morning, Sanchez allegedly approached the truck driver who was doing his assigned work at a hotel loading dock and escalated a dispute about the victim parking there, according to police and prosecutors. Let's look at the documents. I think I actually have the actual arrest, or not the arrest, the probable cause affidavit. Because we would. Here. So here's the PC affidavit. I know a bunch of people have reviewed it.
So on the affidavit, so here's the background stuff. Sanchez was the number 5 overall draft pick by the New York Jets in 2009. Actually, wow, the Jets were good? No. In 09? No way. He had 2 seasons that were decent. He led the Jets to back-to-back AFC Championship appearances in the first 2 seasons. Oh, but then his record was just overall losing 14-17 with 39 touchdowns, 36 interceptions in his next 2 seasons. Ouch. Okay. Then he had brief stops in Philly, Dallas, and Washington, but never played in the playoffs. Oh, he played in Washington. When did Sanchez play for Washington? Oh, no. Anyways, here's the probable cause affidavit. On October 4th, 2025 at 12:35 a.m., we're dispatched at 301 West Washington Street on the reports of person shot. When officers arrived, they came in contact with the male, later identified as Mark Sanchez, with several stab wounds to his upper right torso area. The second person was located in the alley west of the location near 50 South Senate Street. The second person, later identified as PT, had a laceration to his left cheek. Was transported. They were both transported to the hospital in critical condition. Aggravated assault detective was requested to be paged through the control by an officer on the scene. With Detective Joshua Slayton was paged at 12:54 a.m. They speak to everyone involved. They end up pulling video. Altercation was there. They get someone who observed at least some of this. At the location, picking up his kid, and he saw a larger male wearing a black shirt, another male who was a truck driver interacting with each other. First thought they were friends, didn't pay much attention. Then thought it was odd because the 2 men went to the other side of the truck out of his view. Then he noticed that the truck driver tumbled over to the opposite side of the curb, and the person in the black shirt was standing over him. Thought they might have been wrestling or something. Then the male in the black shirt ran northbound in the alley, and the truck driver stayed with the truck. Didn't see anything further. Didn't know what happened, but assumed it was some kind of serious because the police started showing up. So that's what we have by way of some of the allegations. They do additional investigation, and it turns out that what originally appeared to be the reporting that said or suggested that Mark Sanchez was injured in this, and that perhaps the injury was because he was attacked, ends up being that Mark Sanchez is quite likely not the best guy in this scenario. Now, why was I angry at the media why was I angry when I was looking for an article to give you guys a summary of that? It's this. How an altercation between Mark Sanchez and a truck driver revealed the pressure on the leaders of America's big cities. What the fuck? What? How an altercation between Mark Sanchez and a truck driver revealed the pressure on the leaders of America's big cities. I don't understand. And I just, hi, we're CNN. Why are we losing viewers all the time? Why are we losing credibility? Why are people saying that we're not credible anymore? The fuck is this? And you show Mark Sanchez looking up to the heavens like he's this. Observers from around the country tuned into Monday's news conference featuring Marion County, Indiana prosecutor and the Indianapolis police chief. Interesting to hear more about the bizarre incident involving former NFL quarterback and current analyst Mark Sanchez. What they got was an argument in defense of downtown Indianapolis from 2 of the area's top law enforcement officers after days of heated viral online criticism. Their responses revealed the pressure local leaders are under at a time when crime is in America's biggest cities under an intense microscope because of the administration's threat to send in federal troops against local wishes. Really? We're going to make this a national thing? That wasn't what I gleaned from any of this probable cause affidavit. You know this probable cause affidavit? This probable cause affidavit is showing me, oh my gosh, that we have a... What the fuck? Come on. Come on. Just report on the fucking story and tell us what's happening. Don't take the broader implications of everything to all the nth degree. Guys hear me talking about this crap all the time. Individual cases are not like the banner guard for every cause. What a stupid article. And if that really was the press conference, is that really what the press conference was? Is that what they said during that entire thing? I might have to pull it up. I don't know. That's really fucking annoying. So why was this upgraded to a felony? I'm giving everyone a warning. I'm giving every single person a warning right now. Here's the warning. Trigger warning. When they said that they saw the injuries and that's what gave rise to them upgrading the charges. In my head, I was thinking, wow, those injuries must have been pretty significant, indicating that either a weapon was used. Hettinger, the point is well taken. I kind of want to see the press conference now. I'm very curious on this. So, I don't know. How serious would the injuries have to be in order to upgrade it to felony? Here's the warning. The warning is, I'm showing you the picture. It's being published. You're going to see the picture. If you're not cool with seeing someone injured, then look away. So, warning 3, 2, and here is the photograph. Look at this photograph. Yeah. Yeah. No, that's why that was upgraded. Right there. That is not a small laceration to his cheek. When we talk about laceration, like the officers observed the laceration, you're thinking about like a cut, like a little small cut. I'm not thinking the dude's cheek is split open like it was gashed. And I would say that is some pretty significant damage. This isn't just two dudes that are randomly wrestling. This is not Sanchez. This is the 69-year-old truck driver. This is the 69-year-old truck driver. Yeah. So for those of you wondering, well, that seems excessive. Why would we upgrade this to a felony? Are they just trying to make a point? That doesn't feel like they're just trying to make a point. Do we need to remember like how big Mark Sanchez is? Let's see. Let's look this up. Mark Sanchez. Mm, 6'2", 232 pounds. 38 years old. So I would say that photograph itself warrants upgraded charges. But we also have additional reporting from, lo and behold, TMZ, who obtained a video that's been widely publicized, not just on TMZ, but they've shared it all over, that shows there's the truck right there, the individual's truck. Looks like it's taking cooking gas. There's Mark Sanchez. And it is, they described it as him stumbling. Oh, that's I mean, he doesn't look sober. I'll tell you that. I wouldn't necessarily aimlessly walk in the opposite direction. Someone walks by, sees him. Didn't that look like the dude was just kind of staring back at him like, you okay, bro? All right. Runs down the alley. But why? As a guy, that looks like the maneuver that we engage in to try and find a place to pee. Just me. Like, shit, the bar's closed. I got to find a place to pee. That's what that looks like to me. Just the idiot outside observer. So you got Mark Sanchez walking. Now he's running again. So maybe he's still looking for a place to pee. Well, he's running back. Oh, that's when he's running away from the scene. Okay. Holy crap. You can see the stab wound. So where's this? Stab wounds are right there. Oop. Right there. You can see the shirt. Here's kind of bloody. And there's the additional bloody shirt. What a fucking mess. What a strange. That's weird. Do they have anything else to add on this point? No, it's just looking like he's wandering around. Running. Now they're calling this the alleged victim, and they have chosen who they're going to charge in this incident. So police say they've seen multiple videos of the actual attack. Those are not yet public. So those have not yet been made public. But what we also have is the civil complaint. Now, the civil complaint is pretty interesting because they actually sue Mark Sanchez and Fox Corporation. They're suing their company. They're suing Fox. And the way they're trying to get Fox in this lawsuit is vicarious liability, that they should have known that their employee posed a risk, and they had a duty to make sure that employee did not engage in assaultive behavior when they were acting in furtherance of the company interests. Very, very, very simple complaint. So here's the factual allegations, which largely mirrors the actual allegations, but actually does it in kind of a shorter way. So one of the reasons why I like some civil complaints, look at this, nice, concise paragraphs, individually separated by numbers, so you can actually navigate pretty easily. Probable cause affidavit, just a whole lot in one thing. So it's kind of complicated. Now, I get why. It makes sense. You actually have to tie it to the individual that's saying the things. But now we have the civil suit. So the factual allegations: Sanchez, employee of the defendant Fox. Defendant Sanchez traveled to the state of Indiana as per his employment duties for the defendant. Commentated on the game Colts versus the Raiders on October 5th, 2025. At all times relevant. Perry Toll was performing his duties as an employee of the company, specializing in commercial cooking oil recycling and disposal at the loading dock area of the Westin Hotel. Sanchez approaches, appearing intoxicated, instigated an altercation with plaintiff, claiming that plaintiff could not be at the location and defendant had spoken with the hotel manager. When in that video did you speak to the hotel manager, Mark?
During the interaction, the defendant, Sanchez, attempted to enter and later entered the work truck without permission and blocked the plaintiff from accessing his cell phone to contact his manager. That's a problem. The situation escalated when defendant Sanchez physically blocked and shoved plaintiff, leading the plaintiff to use pepper spray in self-defense. Despite pepper spray, Sanchez continued to advance towards the plaintiff, resulting in a physical altercation, which resulted in plaintiff suffering significant injuries to his head, jaw, and neck. 12:35 a.m., police officers get dispatched. They find Toll bleeding profusely and severely injured. Sanchez was arrested for battery and unlawful entry to the motor vehicle and public intoxication. So here's the count one, assault and battery. Pretty simple. As to Mark Sanchez did the assault and battery and caused significant injuries, which are going to include just compensatory damages, punitive damages, I believe, because you have intentional act like this. So as to the negligent hiring, retention, and supervision, this is going to come down to what Mark Sanchez's actual role was. What level of supervision Fox had as to all of its correspondence, whether Fox arranged for the hotel, whether Fox arranged for security to escort Mark Sanchez to and from, whether Fox arranged and paid for the bar bill, whether they knew of his drinking habits beforehand. There's a lot here. Now, Fox is going to fight like hell against this because they're the deep pockets. They're the ones who don't want to be found liable in this case because those injuries are significant injuries that you're going to get a jury award. The other thing is the allegation that Fox knew or should have known about the defendant's unfitness and propensity for drinking or harmful conduct. Now I'm going to look at the damn employee file and I'm going to look at prior reports from everything else. Is this asking for a quick settlement? I don't know. It's not likely this is going to get resolved. You guys, and this is often the case, criminal case will come first. The criminal case will come first. It will get resolved first because the civil case is going to wait until the defendant chooses or does not choose to exercise their Fifth Amendment right not to testify. They're going to wait till the criminal matters are fully resolved, and then they're going to bring and prosecute the civil case. You saw it in this Karen Reed case. You see it everywhere. So this is just foot in the door. I don't know. Are they trying to get a quick settlement out of Fox? Possibly. That might be the case. Because if I'm Fox, I'm doing the math on what discovery costs. I'm doing the math on what the litigation cost might be. And I'm also doing the math on how likely it is that Sanchez is going to get convicted and or found liable in this case. Compensatory damages amount to be determined at trial. Punitive damages amount to be determined at trial. Costs and expenses and other relief. So quick and simple. Of all of the damn cases, the case involving just one of the more significant injuries is the one that has a 5-page complaint. Look, brevity. It exists. It's possible. Sailhounds, was there a confrontation inside the truck? If so, I know what I would be thinking as a juror. I think the allegation is he blocked the exit to the truck. So false imprisonment, basically. Which he didn't allege that though. I don't know why. I would have put that in there. I don't know. There wasn't really a need to file this immediately. I don't know why. If I'm plaintiff's counsel, I'm waiting for a minute. I'm waiting to get a little bit of information and then I'm filing. But again, I don't practice this area of law all the time. I don't see anything wrong with him filing it right now. So it is what it is. I think Sanchez, though, I don't know. We're going to have to see if his defense team tries to run a defense of I don't know how he would say that he was engaging in self-defense. Maybe just that he wasn't the initial aggressor. It's possible. Where did the knife come from? I think the knife ended up being the truck drivers.
So the statement from PT. So this is the truck driver, which tracks the video, says that Sanchez opened his door and that the driver exited the truck. They had a conversation where Sanchez told him he could not be there at the loading dock and that he, Mr. Sanchez, Mark Sanchez, had spoken with the manager of the hotel. The truck driver didn't have his hearing aids in because his truck is very loud when he's exchanging frying oil for the hotel. So he had to lean in close to Sanchez to hear him. When he leaned in, it said Sanchez smelled of alcohol. Pardon me, that was an onset yawn. I apologize for anyone else who overheard that, saw that, and otherwise yawned. It's been a week. So he smelled of alcohol, and his speech was slurred. The driver was confused and stated he needed to contact his manager to find out exactly what was going on. Described Sanchez, whom he did not know or did not recognize. He was well dressed and groomed, so he assumed he could be the manager of the hotel. Sanchez climbed up into the cab of the truck and leaned over the driver's seat and looked in towards the middle area between the seats. All right. Driver told Sanchez that he was not allowed to be inside the truck, and Sanchez came down. Sanchez kept repeating that he had spoken to the manager. They did not want the truck driver to do that, replace the fryer oil. There's going to be some real interesting conversations or information. Where did the manager thing come from? Where is that? Like, how does that fit into this damn story? Okay. Truck driver said at this time he had a problem. Tries to get a cell phone from the truck, and Sanchez blocked him from trying to call the manager. Truck driver then walked around the truck, that was reported by the other person, and Sanchez followed him but stood near the front of the truck. Truck driver is seen walking westbound off camera to the opposite loading dock, trying to flag down one of the security officers, then walks towards the passenger side of the truck. Sanchez walks with him. Truck driver attempts to get in the passenger side of the truck, but was blocked by Sanchez. Driver walked back around the driver's side again to try to get his cell phone from the truck. Sanchez shoved him. He reached into his pocket and grabbed his pepper spray and sprayed Sanchez in the face. So the pepper spray appeared to have an effect on Sanchez for a moment, but wiped his face and again advanced towards the truck driver. Thought to himself, this guy's trying to kill me. So he pulled his knife. And when Sanchez came at him, hit him 2 or 3 times with a knife. Found himself lying, where he said, found himself flying back into the dumpster and falling onto the pallets on the ground. While he was on the ground, he was not aware of what Mr. Sanchez was physically doing to him, whether he was punching him or otherwise striking him. He could only see the feet of Mr. Sanchez coming at him. Life or death. Yeah. So if that is on video, let's say hypothetically speaking, that entire encounter or most of that encounter is on video. If you are Fox and face the possibility of that video being played as to one of your employees, and let's say hypothetically speaking, you have a past report from another time when this employee was in your supervision and got hammered drunk and maybe started a bar fight. I don't know. That would be a pretty big fucking problem. And if you knew about it and you didn't do anything to prevent it from happening in the future, that could also be a pretty big problem. So that's where that sits. We're just going to have to see. No, I'm saying this, the KPT, the hypothetical I'm saying is that let's say that discovery reveals that there was another situation. And I want you to think about this. Do you think there is anyone else who have been on these trips who could possibly have observed Mark Sanchez drunk? Just think about it. If that's the case,
and they have other witnesses who are saying that they knew this happened or this was a problem, then you can run yourself right into a big issue. But that is, like I said, that's for another day. That's for when more of the information comes out. Right now, we don't know a whole lot. TMZ is doing what TMZ does, which is to go and investigate and do all their stuff because they love salacious content. I don't fault them for it. That's their business model. But what we're doing is just trying to figure out where everything stands from a legal perspective. He's currently facing those charges. They've been upgraded to felony charges. The injuries tell us why. Civil complaint has been filed. Everything is now tracking. The Sanchez team has been quiet, which is the right move. Hey, look. Lawyers that know what they're doing. Wonderful. But okay. So that's kind of it, guys. I didn't have too much tonight. Like I said, it was a long week, and there really wasn't too much going on in court. If there's any other cases you guys want to talk about, if you guys have any questions about, then we're happy to go through those. I'm happy to keep an eye on them next week. Next week, I have a far better trial week. Way better. A lot easier. So yeah, that Denisha Blyther, that was the funny thing about it too. Not funny, but the speed with which the civil case was filed. It was filed like the day after the criminal charges were brought. So I don't see how I don't know that there was a real advantage to doing that other than trying to pressure Fox to come to the table really quickly. Yeah, next business day. Oh yeah, Donna Iddleson's sentencing is 3:00 on Monday. I knew that. So that one. Matthew McClellan, I have to dig around the documents on the Kelly Fitzsimmons case. I don't know that one. NFL LSU case. What is that one? What is the NFL LSU case? Let's see. NFL LSU case. Is this the Kyron Lacey case? Oh, this one is complicated. I remember seeing this. Yeah, this case is really wild. This was, so just as I know that some individuals have gotten heat over statements made about this case. Louisiana State Police have released video of a deadly 2024 car crash that authorities contend was caused by reckless driving by Kyron Lacey. 11-minute video came in response to other footage given by the defense attorney, who said it showed a former wide receiver couldn't have caused the wreck because he was too far away from the collision. They're going back and forth on this. Days before the grand jury hearing of this case in April, Lacey died of an apparent self-inflicted gunshot wound after fleeing a traffic stop near Houston. So this case is wild. It is very complex from my understanding of it. I think that a lot of people are dug in pretty firmly on this one. So we're going to just, I will take a look at that because I actually do have a bit of an interest when this stuff overlaps. I think I can take a look at that and see if there's anything that we can learn about that, whether there's going to be a family lawsuit filed in the civil claim. We'll have to see. I know that a lot of people are having foot in mouth syndrome with comments made at the aftermath of that. It's just kind of odd. All right. I think that's going to be it for us this evening. Why don't we have a better grasp on it? Because the police thought that, put it this way, police thought their investigation was pretty straightforward and simple. There was a grand jury that was impaneled to presumably issue an indictment against this individual. Individual dies of what appears to be a self-inflicted gunshot wound, and the police believed that the person inflicted the gunshot wound because they were facing the possibility of indictment. So that's their side of the story. The other side of the story is that Kyron Lacey, should not have been indicted, should not have been facing indictment, because there was no evidence to suggest that he was the cause of this prior incident, and that the police and that the LSU investigation, or not the LSU, the investigation was being wrongfully placed too much pressure on the individual, and they took their own life as a result of the pressure, not necessarily because they did anything wrong. So you have two really big competing narratives that are very, very, very emotionally charged. So it is both sides of this, and I don't know. I will watch the video, but there's probably more than just the video. And there's probably a lot of information. This is one of those cases where you dive in and start making a comment on one side or the other. I think it's going to be, I don't know. You never know what you don't know. So I'll have to take a look at the video, see if I can't figure something out. For those of you who are here, please hit the like button. I know it's been a little bit of a short stream and a little bit chaotic. Next week, we'll be back. We'll have some more fun things to talk about. I think that we've got the Don Adelson. That sentencing will likely be live streamed, I believe, on Monday at 3:00. KPT, I'll watch the videos. I will. It's going to be pretty interesting. And then I actually want to see if there is a case that comes out of it. That's the biggest curiosity I have right now. Lori Leanne, 38 months. Happy 38 months to you. Have a great weekend, everyone. Many hugs indeed to all. Equality, 3 years is in this awesome community. A lot of people hitting 3-year anniversaries this year, or this month. That's phenomenal. Thank you guys for being here for that entire time. Sticking around. I'm waiting for the Mrs. Runkle update as well. I know that there are concerns, but I'm sure that Ian will let people know if and when he is able to. I don't have any updates as of right now, other than we are not facing a situation that I am seeing from the outside in as being like needing all of the possible. It's not the worst thing from what I'm seeing right now, but I don't know. I'm going to let Ian comment on that. That's his issue, but keep him in your thoughts, please. I know that she's in the ER, so keep him in your thoughts. Equality, 3 years in this community. Jackie Lind, headline makes me think CNN article is AI slop. Check to see if byline includes attribution to other news source. I don't know. I don't think so. The byline, no, it's actually analysis by Kyle Feldscher. That's what it is. And it looks like the article is about the press conference rather than anything else. But I don't know that that's where I would have gone with this. It seems like that that's trying to find a narrative in a set of terrible facts. Not every set of facts, not every crime is there to advance a narrative. There are other things. Just what a mess. Matilda, good morning, 6:45 a.m. from the Netherlands. Good morning to you. And now that it is morning, my time, 12:51, indeed, I'm going to be bidding you all good evening. There, I already did. I pulled the ginger ass. Made the comment, made the good evening, bidding you good evening. Doth protest too much. Doth protest too much. That's going to be the saying in all of my pleadings this coming week. I will probably put that as the tagline in my email signature block, where every email that I send to opposing counsel
will end with thou doth protest too much. It's just going to be where it is. So cheers to all of you. Greg is coming in with this additional one. Lacey's investigator was on body cam coaching a witness statement from a witness that contradicted everything that was said. Wow. All right. I'm good. That's going to be very interesting. That's going to be quite interesting. Like I said, it looks like both sides have dug in their heels. So I guess we're going to have to see what ends up coming from this. For those of you who are still watching, please hug your loved ones. Have a great weekend. For those of you who watched it all, have a great weekend. Replay crew, we love you. Please hit the like button. Comment on any cases you actually want us to follow coming up. Adelson will be on Monday. I will not be streaming. I imagine Ian will hopefully be streaming during that Monday evening. Richins is the case beginning in February. Walshe is pushed, so we have some time to figure something out. And then we'll just follow what we're going to follow. Have a great weekend. Good night to all of you. Get out there, go do something, make something. You'll feel better. I've got to make some clean in this house. There will be making of clean this weekend. That's going to be the fun part. And then there's a lot of the Kelsey Fitzsimmons stuff. Ooh, yeah. I'm seeing people want me to do a deep dive on that. So I'm gonna have to find those pleadings. If we have a source of those pleadings, please let me know. I'll keep looking at those and I'll see if I can't get caught up to speed, because I would like to follow a case that's more consistent and has something going on. That's going to be pretty interesting though. Good night to all of you. Have a wonderful weekend. I will see you next time. Enjoy. Night, folks. Bye.